Mute or unmute.
ಕೋಟೋಲ್ 12 ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? ಕೋಟೋಲ್ 12 ಸುರೇಶ್ ಸರ್, ಶ್ರೀಪಾದ್ ಸರ್, ಶ್ರೀಪಾದ್ ಸರ್. ಕೋಟೋಲ್ 12 ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ
ಮ್ಯಾಮ್ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ಲ?
ಇದೆ ಮೇಡಮ್, ಇದೆ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
ಸರ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ ಸರ್. Page wise adjustment. Page number 2, page number 1, serial number 1. Page number 2, serial number 2 to 4. Page number 3, serial number 5 to 7. Page number 4, serial number 8 to 13. Page number 5, serial number 14 to 23. Serial number 15. Learned counsel for appellant at the request of learned counsel for the respondent. This matter of 2 weeks. 22. 22 ಯಾರಿದ್ದಾರೆ? ಇಲ್ಲ 22 ಇಲ್ಲ. ಯಾರು ಸೈಯದ್ ಅಬ್ದುಲ್. Page number 6, till number 24 to 28.
24, my lord.
Yes.
Will take notice for that.
24, Vijay Kumar is directed to take notice for respondent number 2. Notice to R1 is dispensed. Page number 7, serial number 29 to 33.
My lord, 32, my lord. ಅದರಲ್ಲಿ ಡಿಲೇ ಕಂಡೋನ್ ಆಗ್ತಿದೆ. ನಾನು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಇನ್ನ.
Okay, okay.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇರುತ್ತೆ.
You are filing wakalat for which respondent, Mr.
32 ನಲ್ಲಿ sorry my lord, 35. I'm sorry.
Yes. Which one? 30? 31. No, first you comply the top subjection. We don't know, your case may be dismissed in that non-compliance. Why can I tag it before issuing the notice? You comply the top subjection. Yes. Page number 8, serial number 34 to 39.
My lord, 35, my lord.
Yes.
ಇದರಲ್ಲಿ ನಾನು ಇನ್ನೂ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ.
At the request of counsel for appellant, the respondent, release this matter next week.
Obliged.
Page number 9, serial number 40 to 45. 42. Kishore Kumar Reddy. Yes, at the request of counsel for respondent, release this matter next week. 40. 40. Yes, what you want? Next week. At the request of counsel for respondent number 1, release this matter next week. Page number 10, serial number 46 to 52.
Lord, 51, my lord.
Yes.
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಅವ್ರು ಯಾರು ಅಪೀರ್ ಆಗಿಲ್ಲ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡು.
Yes, yes. Admit.
Please.
52. Yes, Mr. Vishwanath. At the request of counsel for the appellant, release this matter of 2 weeks. Page number 11, serial number 53 to 57.
My lord, 56, my lord, I am to file wakalat for R3, my lord, in this matter, and the steps in my matter.
Yes.
It may be called after 2 weeks since, my lord, I will file wakalat and also take steps.
56 only. 2 weeks time is granted to do the needful. 50? 55. Yes, Mr. Next week. At the request of counsel for respondent number 1, release this matter of 2 weeks. Page number 12, serial number 58 to 60.
Yes. 60 ನೀವಿಲ್ಲಲ್ಲ Yes.
I am for the appellant in some 4 matters, my lord.
Yes. This matter may be called along with that MFA. Yes. Yes.
Serial number 60, my lord.
Serial number?
60, yes, Mahesh.
Yes, Mr. Mahesh.
I am not a appellate for 4 appeals.
Yes. Now that PB Raju said one more connected matter is there. We'll call along with that. Yes.
Page number 30, serial number 61 to 63.
My lord, 62 may kindly call me.
Tito, at the request of counsel for respondent next week.
Appellant. Respondents are will sir.
Yes. Aye. Yes, at the request of counsel for R3, release this matter of 2 weeks.
Page number 14, serial number 64 to 66.
Yes, 65.1 at the request of appellant, release this matter.
I am ready, my lord. I am ready. Matter is very simple.
Next
Act
week.
liability policy.
Now that appellant counsel wants time.
Okay, madam. Next week.
Yes. One time at the request of counsel for respondent number 2, release this matter next week.
Page number 15, serial number 67 and 68.
68. Yes, Mr. Next week. Yes, 68 at the request of counsel for the appellant next week.
Page number 16, serial number 69. Which number?
I am for the appellant.
37.
I am ready.
Along with that. Yes. Tomorrow. Yes.
Which number 1, hearing interlocutory application matter, serial number 1 to 15.
This.
Admission matter, serial number 16 to 20.
Notice.
Number 2, for order, serial number 1, Manjula Tejasvi for appellate, connected matter, Mohammad Umar Farooq, K.R. Ramesh, K. Kantaraj.
Yes. Yes, at the request of counsel for appellant, week's time is granted to do the needful. Yes, they have to take steps, paper publication, we don't know when it will be. Yes.
Serial number 2, Raghavendra K.N. for appellant, Dayananda K.V.
Yes. Non-compliance of the office objection. Yes, Mr. Raghavan. Acceptance of wakalat. Insurance company is not there. You are appearing for whom? Respondent number 1 is the owner or no, you are appearing for the owner or a claimant? Claimant. What is this order sheet? Where is that judgment? What has happened to this case, Mr.? Whether the petitioner proved that deceased Venugopal died due to the traffic accident, so and so. You are owner of the vehicle. Claimant. Why that vehicle is not insured? Then owner has filed an appeal. What is that 14,81,000? Who is appearing for that? Raghavendra K. Non-compliance of the office objection for 16. Accepted wakalat filed by Notice ಆಗಿದೆಯಾ? 3 weeks time to grant that office objection. Finally, 2 weeks granted to comply the office objection. 4 weeks granted to comply the office objection. Notice is not ordered. You have filed an wakalat. Why they are not interested to comply the office objection? Where, who is that? Raghavendra here. Yes, pass over. I will dismiss it. They have given 6 times for compliance of the office objection. Yes.
Number 3, Sripadri Shastri for appellant, S.V. Sudhakar Reddy.
Yes.
My lord, my name may be deleted, my lord.
Oh, you are not there.
No,
Yes.
AK Bhatt is appearing.
Office is directed to delete the name of Sripadri Shastri. Yes, Sudhakar Reddy. Ready? Quantum. Liability is not in dispute, Mr. Yes, what is this, Mr. Respondent number 2 being the insurer of the offending vehicle is directed to deposit. There is no dispute in it. Why? Huh? Yen dispute idea idralli? Then yes, what is that income? Pass on. Yes. If it is any difficulties, I will grant. Wait.
Number 4, Girish M.K. for appellant.
As per that office note, appeal is valid more than 15 lakhs. And post this matter before the division bench having roster after obtaining. Post before the division bench having a roster.
Number 5, S.V. Agade Mulkund for appellant, Kashinath J.D.
Office objection raised on I-1 of 2022 for releasing of the amount so and so. Yes. Office is directed to secure original records from the tribunal.
Number 6, Chetan B. for appellant, B.C. Chivanegowda.
Yes, Chetan. Office objection raised on the wakalat filed by the BC. Yes. United India. Wakalat written with office objection. Executive so memo for dispensation of notice to R1. Notice to R1 is dispensed. Delay of 40 days in filing an appeal is condoned. Weeks time is granted to rectify the wakalat. Yes.
Number 7, Prasanna V.R. for appellant, Janardhan Reddy, Parashuram A.L.
Yes.
Appear for 2 and 3, Mala.
But step to be taken for R1 portions are written deceased. Who is R1? No, who is appellant? No, what has happened to that other respondent? Somebody is representing. Yes, Mr. 2 and 3, you are representing.
I'm representing for 2 and 3, Mala. I'll file my objections. If you'll also grant some time, I'll file my objections.
For what? Objection to what, Mr. Respondent number 1. How he is related to that deceased, madam? Two and three are the
Mother and brother of the deceased.
mother and brother. Father is dead now. Yes, Mr. We have any objection treating that 2 and 3 are the LRs? Is there any other LRs?
No, my lord.
We can allow that application. Yes.
Please.
Yes. Memo hakidira. You have not filed an memo. Kodi. Learned counsel for the appellant has filed a memo. Stating that the respondent number 2 and 3 are the only legal representatives of deceased respondent number 1. They are already on records. They may be treated as LRs of deceased R1. Memo is taken on record. Respondent number 2 and 3 are treated as LRs of deceased respondent number 1. Appellant is permitted to amend the cast. Counsel appearing for 2 and 3 has said has no objection to allow the memo. Permitted to amend the cast title. Amend madi. A week's time is granted to steps R4. You amend it now, right?
Number 8, Shankara Reddy for appellant. Shankara Gulli.
Yes, furnishing a PF issue notice to respondent number 2, who is R4. Yes, week's time is granted to do the needful.
Rajanna for appellant, B. Pradeep.
Yes, why? Week's time is granted to do the needful.
Number 10, Nagaraja Reddy D.
Council submission with regarding to the topic objection. What is the topic objection? Discharge summary illa hakidiru. Additional document. Page number 39. 38 is the Nodi adonde nan option.
Script at page number 39 and 40 to be furnished.
Yes. You type to copy haki adrille na idu. Yes, week's time is granted. Memo application memo hakbekala dispensation order. You have to file an application for dispensation. You have to file that dispensation, or you have to make a note in that office regarding that. Where? Yes. Which is that serial number? 10. What is submission regarding this? Office objection is kept open. Issue notice to respondents. Yes. In the meantime, if file it, Mr.
Number 11, Rajashekara Siri for appellant, division.
As per that office note, the appeal is valid more than 15 lakhs. Hence, post this matter before the division bench having in a roster. Yes.
Number 12, Mahadeva Swami P for appellant, Lata Prasad.
Yes. Yes, where is that other side? Yes. 2018. Hmm. 15 days. Yes. $3,000. It's not either a tribunal or upper limb disability 52, whole body 26. How much tribunal has taken? 52%, 26%. Huh? 57 years. Why the tribunal has taken only 10%? 12% and either already. Income? 10,000. What are that other head, Mr.? 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ attendance charges. Medical bill ಕೊಟ್ಟಿದ್ದಾರೆ. future medical expenses. What is that loss of income later period? What is that interest 9%? Notice to R1 is dispensed. Liability dispute till 1. ಅವ್ರೇನಾರು appeal ಇದೆಯಾ ನೋಡಿ. Mahadev Swami P. Learned Council appearing for claimant has contended that due to that extent, claimant has suffered grievous injury. Dr. S.C.A. Somsekhar has been examined as PW2. In his evidence, he has deposed that claimant has suffered physical disability to upper limb 52% and whole body disabilities is 26%. The tribunal has assessed whole body disabilities 12% is on lower side. He further contended that at the time of the accident, claimant was earning 15,000 per month doing a coolie work. The tribunal has assessed notional income of the claimant as 10,000 per month is on lower side. Further contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 15 days. He has suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. So and so, learned counsel appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 26% disability to whole body, considering that injury suffered by the claimant and considering his age and avocation, tribunal has rightly assessed whole body disabilities 12%. He further contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under that circumstances, tribunal has rightly assessed whole body disability, rightly assessed the notional income of the deceased claimant as 10,000. He further contended that considering that the evidence of doctor injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, she contended that interest awarded by the tribunal 9% is on higher side. Hence, she sought for dismissal of the appeal. Third, the learned counsel for the parties arose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 10/9/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA11 EJ 9261. Due to the accident, claimant has suffered the following injury. Dr. S.C.A. Somsekhar has been examined as PW2. With evidence, he has deposed that claimant has suffered permanent physical disability to right upper limb 52% and whole body disabilities is 26%. Considering that evidence of doctor And considering that age and avocation of the climate, I am of the opinion that all body disabilities has to be assessed 14%. Even though climate has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2018, notional income has to be considered as 12,500. At the time of the accident, he was aged about 57 years. The multiplier applicable to that age group, which is 5, multiplier 5 ಹಾಕಿದಲ್ರಿ 57 correct? Then why 5 was calculated? Huh? Even you have not taken any ground in that appeal. The age is not nowhere you have taken that ground, mister. That means to say that is it 56 or 67? Then why you have not taken that ground? If that is the case. ಇದೆಯಾ ಅಲ್ಲಿ ಆಧಾರ್ ಕಾರ್ಡ್ ಎಕ್ಸಿಬಿಟ್ ಪಿ 11 ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ ಕಾಪಿ? No, is it 57 or 67? Then why you have not challenged in that ground saying that this is wrong? What oversight, mister? That will make lot of difference. Outer on ground third. He further contended that even though tribunal has rightly given a finding that climate was aged about 57 years, the multiplier adopted by the tribunal is on lower side. Really, he was aged about 57 years. The multiplier applicable to that age group is 9. Accordingly, loss of future earning has been reassessed as follows. 40%, 1,89,000. To that extent, climate has suffered the opposite injury. He was inpatient for a period of 15 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the climate, I'm inclined to enhance the compensation for considering that the climate is entitled loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest. 3 months. Yes. That's all. If I have concluded that monthly income is 12,500, it's 3 months. Yes.
With HC for appellant, Ravish Bindi.
Yes. Notice to R1 is dispensed. Ready? Yes, where is Vinny? Sir.
Number 40, R. Shashidhara for appellant, EI Sammati.
Ready? $2,000? Yes. 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 Doctor has said 32% disability to that limb. ಆಯ್ತು ಇನ್ 1% ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ನೀವ್ ಎಷ್ಟು ಹೇಳಿದ್ರಿ? Yes. Criminal is considered 10,000. 9,000. 18, 12,500. Yes. 13 days. Loss of future earning capacity, pain and suffering, guest injury. How many injuries you have suffered? What are that? 2 injuries. Loss of immunities, nourishment ಕೊಟ್ಟಿದ್ದಾರೆ, medical expenses, loss of income during the later period. Loss of pain and suffering, immunities during the later period ಕೊಟ್ಟಿದ್ದಾರೆ. What is that interest? 9%. That's all. Well, Shashithar, Senate Council appearing for climate has contended that due to the accident, the climate has suffered grievous injury. Doctor has been examined as PW2. In his evidence, he has deposed that climate has suffered 32% disability. The whole body disability is assessed by the tribunal. 10% is on lawyer side. Secondly, he has contended that at the time of the accident, climate was earning 25,000 per month. Tribunal has assessed notional income of the climate as 9,000 per month is on lawyer side. Lastly, he has contended that due to the accident, climate has suffered grievous injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lawyer side. Hence, he sought for enhancement of compensation. For contra, GD, Sammati, Learned Council appearing for insurance company has contended that even though doctor has deposed that climate has suffered 32% disability, it is only related to the limb. Considering that whole body, tribunal has justified assessing 10%. Secondly, he has contended that even though climate has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under those circumstances, tribunal has rightly assessed notional income of the claimant as 9,000 per month. He further contended that even though considering that the evidence of doctor and injuries suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses just and reasonable. Lastly, he has contended that the interest awarded by the tribunal is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, Pharaoh's judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 5/4/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KS 17 EP 0136. Due to that accident, claimant has suffered the following injuries. Dr. Rudramani AK has been examined as PW2. In his evidence, he has deposed that claimant has suffered permanent disability to the extent of 32%. Considering that injury suffered by the claimant, considering his age and avocation, I am of the opinion that whole body disabilities can be assessed 12%. Even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines. For the accident occurred in 2018, 12,500 has to be considered. At the time of the accident, he was aged about 45 years. The multiplier applicable to that age group is 14. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, claimant has suffered following injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000. Loss of immunities from 10,000 to 30,000. Loss of income during the later period has to be granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest.
Serial number 16, Pawan Chandra Shetty H for appellant. Yeah, Lakshmi Narayana.
I am appealing for respondent to me. Milord Lakshmi Narayana.
Yes, ready?
Ready, Milord? I am ready.
Yes. Yes, Mr. 2020, yes. 45, yes. 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 14,500. Yes. How many days you are in that hospital? 35 days. Yes. Five. Towards left upper line. Towards disability, medical expenses, pain and suffering. How many injuries? Really there. Yes. Fracture, grand knee splintic injury, ankle capture, left lower liver laceration, left ankle communicated, displaced fracture, ankle, multiple previous injuries all over the body. Three major injuries. Yes. 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 And nourishment, attendance charges, other loss of amenities, Kotila. What about that interest? %. Yes, Mr. Lakshmi.
Milord, 10% disability has been considered by the tribunal. That is in order.
Yes.
Income
Yes.
should be taken as 14,500, Milord.
Yes.
As your lordship has rightly observed, loss of immunity should be given.
Yes.
Pain and suffering should be increased, can be increased. It is
Yes,
only
yes.
25 and a good number of injuries are there. He deserves
Yes, yes.
increased, Milord.
Yes.
Pain and suffering and This attendance charges also 35 days he was inpatient.
Yes,
Only 7,200 given. That can be, it should be increased,
Yes.
my lord.
yes,
Say around 750 per day can be
Yes.
given.
Yes.
Laid up period, 2 months only considered, 3 months can be given, my lord.
yes,
The future medical expense already given, my lord, 25,000 rupees.
yes,
Disability 10% we can continue, my lord.
yes, very fair. So and so learned counsel appearing for the climate has contended that at the time of the accident was earning 15,000 per month. Tribunal has assessed notional income of the climate as 9,000 per month is on lower side. Further contended that due to that accident, climate has suffered grievous injury. He was inpatient for a period of 35 days. He has suffered lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, the
Lakshmi Narayana.
Lakshmi Narayan AR,
Yeah, my lord.
the council appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed that notional income of the claimant as 9,000. Further contended that considering that evidence of doctor and injuries suffered by the claimant, compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 1/1/2020 due to rash and negligent driving of driver of Isha vehicle bearing registration number TN 70Z7014. Due to the accident, claimant has suffered the following injury. Tribunal has rightly assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. The other circumstances, notional income has to be assessed as per the guidelines for the accident occurring 2020. Notional income has to be considered as 14,500. At the time of the accident, he was aged about 48 years. The multiplier applicable to that age group is 13. Okay.
13.
Tribunal has taken 13, 49, 48 multiplier. Yes, 13. Accordingly, loss of future earning has been reassessed as follows. Yes. Somewhere it is discussed. It's shown that petitioner was aged about 48 years. At the same time, accident is further case sheet is 13, which also reflect that he was aged just 48 years.
48 only.
Therefore, tribunal has taken 13 multiplier. Yes. Due to that accident, yes, Banta? Yes. Due to that accident, claimant has suffered the above said injury. Tribunal has considered
25 million. Parents are paying.
10% rate. 13 is that multiplier, mister. Yes.
10% disability.
Yes.
10%.
So due to that accident, claimant has suffered the above said injury. he was inpatient for a period of 35 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 60,000. Loss of income during the later period has to be granted for 3 months. The claimant is all. Attendance charges has to be enhanced from 7,200 to 15,000. The claimant is entitled for loss of income during the later period for 30,000. Enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part.
70,
Gangegowda NR for appellate, Janardhan Reddy.
Yes. Yes. Two 2018. Hmm. 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 Left back chest lift causing deep lower injury of back, hip fracture on the left side, covers process fracture, so to disability. There are 3 major injuries. Yes. Disabilities is correct. What is that monthly income you have claimed? Allow new West. Yes. Gangegowda NR. Learned Council appearing for claimant has contended that at the time of the accident was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 10,000 per month is on lower side. He further contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Reddy, Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 10,000 per month. He further contended that considering that evidence of doctor and injury suffered by the claimant, The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 7.5% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 12/5/2018 due to rash and negligent driving of driver of lorry bearing registration number KA 446903. Due to that accident, claimant has suffered the following injury. The tribunal has rightly assessed whole body disabilities as 15%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. By the circumstances, notional income has to be assessed as per the guidelines 12,500. At the time of the accident, he was aged about 36 years. The multiplier applicable to the age group is 15. Accordingly, loss of future earning has been reassessed as follows. 3,37,500. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 10,000 to 60,000. Loss of income during the later period from 10,000 to 30,000. A loss of income during the later period for 3 months. Loss of immunities has to be enhanced from 10,000 to 30,000. The compensation awarded by the tribunal in the other hand, just and reasonable. Enhanced compensation amount carries 6%. Number 18, National Reddy will take notice. Yes. Notice to R1 is dispensed. R2 is served unrepresented. Janardhan Reddy is directed to take notice. Number 19, Syed Abdul Sabur for appellant, YK Sheshagiri Rao. Yes. Ready, sir. Next. Yes, at the request of counsel for respondent. Relist this matter next week. Number 20, Syed Abdul Sabur for appellant. O Mahesh. Ready. Yes, Mr. Mahesh. Pass over. Number 21, Pawan Chandra Shetty, expert appellant, and Murli Megawat. Ready, Mr. Murli. Nimde the appeal. Yes. Call this matter along with that so and so. Yes. Number 22, Syed Abdul Sabur for appellant, United India. United India, Aridira. You are there, Mr. Yes. R2 is served unrepresented. Reddy is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Notice to R1 is dispensed. Number 23, Sanat Kumar came for appellant. Manjula and Tejas.
Preparing for the appellant, my lord.
Yes.
Preparing for the appellant.
Ready?
Next week.
You are ready, Mr. Sanat?
Next week. Kindly after next week.
Yes, notice to R1 is dispensed at the risk of the appellant. Number 24, number 25, Ravi Kumar NR. Raju. Yes. Ready, Mr. Ready. Yes, Mr. Yes. 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 Hmm. Yes. Yes. Hmm. Really, where is that discussion in that regarding that? Dr. Adarsh is examining PW in his evidence. One doctor stated that treated petitioner related to the injury petitioner has sustained 22.84 disability to right lower limb. Certificate so and so. 22.84 is the limb disability. 1/3 has been taken. Then it is correct. No, that is wrong. Doctor has stated only limb disability. Then tribunal has to, either doctor has to say or tribunal has to consider by 1/3. If doctor has not stated, then after assessing, is there any evidence of the doctor regarding that whole body disability? That is for particular limb. If doctor is not stated, then tribunal has to consider 1/3. That's what Supreme Court said. Then you don't want no particular limb antane heliradu 22.84%. What is that? ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕೊಡಿ. No, this is disability certificate. Where is that evidence of the doctor? ಕೊಡಿ. Mister, even then 7% cannot be taken. Doctor has not assessed anything at all. Disability certificate where he has to give that, split up details, how it will affect. Where is that? Thorough clinical and radical as per that guidelines laid down by that commission as per that with disability motion to 22.8% towards 2.84. Yes. Further, he requires to survey for the so and so. Yes, it is for that only. Yes. 2.4, 4.8. Disability 20.52. Yes, this is each part he has said. Totally, it is comes to 22%. Then now we have to see that entire body, how it will affect. Yes, we'll consider. Not 50%. Yes. Yes. 2017. What is your this thing? Claim of the monthly income? 18,000. Tribunal has taken 8,000. 2017 he gets 11,000. Yes. How many days? Yes. How many days he was in that hospital? Their loss pain and suffering. How many injuries, Mr. Ravi? 2 injuries. Yes. Medical expenses and hospitals. Loss of income during the later period. Tribunal Entmoor. 8 and there are 3 months. Food and nourishment, conveniences. Charges. Loss of amenities ಕೊಟ್ಟಿಲ್ಲ. ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? Where is that? ಟ್ರಿಬ್ಯುನಲ್ ಏನು ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೆ? Where is that? No discussion. Required surgery for implant removal cost of 30,000. Yes, Mr. Where is that discussion? Which is that paragraph? ಎಲ್ಲಿದೆ ನೀವು 6 ತಿಂಗಳು ಕೆಲಸ ಮಾಡಿಲ್ಲ ಅಂತ? Where is that? Where is that? Doctor is also not said. Doctor bari ಒಂದೇ ಪ್ಯಾರ ಇದ್ರಲ್ಲಿ ವರ್ಕ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ doctor has not said. It is there is no in your evidence from your side. Yes. 9% interest. Yes, that's all. Yes. Yes. Right. See, Ravi Kumar NR, Senate Council appearing for Climate has contended that at the time of the accident, due to that accident, Climate has suffered grievous injury. Dr. Adarsh has been examined as PW2. In his evidence, he has deposed that Climate has sustained 22.84% disability. Tribunal has assessed whole body disabilities. 7.6% is on lower side. He further contended that due to that accident, Climate has suffered grievous injury. Was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Lastly, he has contended that due to that accident, Climate has undergone surgery. As per the evidence of doctor, he requires 30,000 rupees for removal of the implant. Tribunal has failed to grant any compensation for future medical expenses. Hence, he sought for enhancement of compensation. For contra, Shri P.V. Raju Learned Council appearing for insurance company has contended that even though doctor has deposed that Climate has suffered 22.84% disability, since it is related to particular limb, the tribunal has rightly assessed whole body disabilities 7.6%. Secondly, he has contended that even though Climate has claimed that he was earning 18,000 per month He has not produced any document to establish the same. Under those circumstances, tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that considering that evidence of doctor and considering that injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, other incidental expenses, and is just and reasonable. Hence, lastly, he has contended that the interest awarded by the tribunal, 9%, is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 25/12/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA14 U0075. Even though due to the accident, the claimant has suffered the following injury. Dr. Adarsh has been examined as PW2. In his evidence, he has deposed that the claimant has suffered 22.84% disability. Considering that evidence of doctor and considering that disability certificate, the disability assessed by the tribunal doctor is related to that particular limb. Therefore, the whole body disability is assessed by the tribunal 7.6% is just and reasonable. Even though claimant has claimed that he was earning 18,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, notional income has to be considered as 11,000. At the time of the accident, what was his age? He was aged about 40 years. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows. 11,000 into 7.6%, 1,50,480. Due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering the evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 40,000 to 60,000. Loss of income during the later period has to be granted for 5 months. The claimant is also entitled for 5 months. Food and nourish convenience charges has to be enhanced from 5,000 to 10,000. Attendance charges from 5 to 10,000. The claimant is also entitled for loss of income during the amenities, 40,000. Due to the accident, claimant has suffered the above said injury. He has undergone surgery. As per the evidence of doctor, he required 30,000 rupees for removal of the implant. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the claimant is required 25,000 rupees for future medical expenses, which it will not carry any interest. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as.
Number 26, Harish Babu PN for appellant, SBI Agdamulpur.
Appear for appellant in this case, my lord.
Pass or pass?
On the next time, Martin Sam.
Yes, at the request of notice to R1 is dispensed. Yes, he wants time.
Number 27, this is Shivanya Goda for appellant, Suresh M. Lathor.
Yes, Mr. Furnishing of process. Yes, you have filed an application. Notice has to go. Suresham Lathur for R1, your notice hogita. Who is that? R1 is dead. Suresham Lathur, you have filed an wakalat for LS. You have no objection, will allow that. Yes. What about R2, Mister? Yes, IA 1 of 2022 is filed for condonation of delay in filing an application for bringing LRs of deceased R1. IA 2 of 2022 is filed for set-asiding that abatement. The respondent has no objection for allowing that application for the reason stated in that accompanying affidavit. Delay is condoned. The abatement is set aside. The LRs of deceased R1 is permitted to come on record. Learned counsel for the appellant is permitted to amend the cost IT. Yes. Week's time is granted to pay the process issue notice to R2. Number 28, Prithviraj BN for appellant. Single appeal ಹಾಕಿದ್ದಾರೆ 3 MSC ಇದೆ ಅಂತ ಮೇಂಟೈನ್ ಸಿಂಗಲ್ ಅಪೀಲ್ MF ಹಾಕಿದ್ದಾರೆ 3 MSC ಮೇಲೆ ಮೇಂಟೈನ್ ಒಂದಕ್ಕೆ ಅವ್ರಿಗೆ ಹಾಕ್ತಾರೆ ಅದಂಗೆ ಹೋಗಿ ಅಷ್ಟೊಂದು 3 MSC ಮೇಲೆ ಒಂದು ಅಪೀಲ್ ಹಾಕಿ ಸೇರು ಒಂದು ಅಪೀಲ್ ಫೈರ್ ತಪ್ಪು ಸುಮ್ಮನೆ owner as well. Yes. Prithviraj BN. Number 28. Prithviraj BN for appellant. None appear. Release this matter of 2 weeks. Number 29. B. Pradeep for appellant. P. Shastri.
I am for appellant, sorry, respondent claimant. I preferred an IA, my lord, for permitted to withdraw. Actually,
Yes.
I filed this IA in the month of March and April, my lord. Now it is posted with great difficulty. 50% direct to deposit my.
On what ground you are challenging, Mr.
Namdu on the appeal is already with Mugispo.
Wait.
Quantum mean.
You are challenging on the quantum. Then I will permit it to withdraw 50%. ಎಷ್ಟು ಆರ್ಡರ್ ಆಗಿದೆ 11 lakh ಆಗಿದೆಯಾ
11 ಅದರಲ್ಲಿ 3,80,000 ಮೆಡಿಕಲ್ ಬಿಲ್ ಇದೆ ಸ್ವಾಮಿ.
wait Mr. Yes. IA 2 of 2022 is filed for withdrawing that amount. Heard the learned counsel for the parties for the reason stated in the accompanying affidavit. IA 2 of 2022 is allowed. The claimant is permitted to withdraw 50% of the award amount deposited by the appellant before the MACT. The tribunal is directed to release that 50% of the award amount in favor of claimant after due verification. All this matter along with
my appeal is 3161/22.
Yes. Week's time is granted to do the needful. Number 30, Rangegowda NR for appellant, B. Pradeep. Yes. Yes of death. Yes. 21. Yes. $21 ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ 15,000. ಕೊಟ್ಟಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಮಾಡಿದಾರಾ What about? Correct ಆಗಿದೆಯಾ? Yes. So and so, Learned Council appearing for climate has contended that at the time of the extent, deceased was earning 30,000 per month. Tribunal has assessed notional income of the deceased as 14,000 per month is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri B. Pradeep, Learned Council appearing for insurance company has contended that even though climate has claimed that deceased was earning 30,000 per month, they have not produced any document to establish the same. The circumstances, the tribunal is justifying assessing the monthly income of the deceased as 14,000 per month. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, Perose, judgment and award. It is not in dispute. What is the name of the deceased, Mr. Ranganath B. died in road traffic accident occurred on 22/5/2021 due to rash and negligent driving of rider of motorcycle bearing registration number KA03 EJ654. Even though claimant has claimed that deceased was earning 30,000 per month, they have not produced any document to establish the same. Under the circumstances, that the notional income has to be assessed as per the guidelines for the accident occurring in 2021. Notional income has to be considered as 15,000. Tribunal has rightly added 25% of the income of the deceased for future prospects, and 1/4 has been deducted for personal expenses. At the time of the accident, he was aged about 41 years. The multiplier applicable to the age group is 14. Accordingly, loss of dependency has been reassessed as follows.
23,750 at the rate of 25%, 18,750 minus 4,687 at the rate of 1/4, 14,063, 14,063 into 12 into 14, 23,62,584.
In other hand, compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is nullified as well. Notice to so and so is dispensed. Memo in view of disposal of the appeal. Memo for return of documents is disposed of.
Number 31, Raghu HR for appellant.
On complaints of office objection for first time, their insurance company. Yes, 2 weeks time is granted to comply that office objection.
Hearing interrogatory application matter, serial number 32, Raghu CPT for appellant, K. Suresh.
Climate. So that you are appearing for climate. Driver of the offending vehicle. What is that finding of the tribunal? On the ground that the ground need not be, it is a question of law. Covered by decision, who is appearing for that? Where is that Suresh? Pass up, Suresh. Pass up. Yes.
Serial number 33, appellant, C20.
Yes, 33. At the request of counsel for responding, place this matter next week. next week ಬರುತ್ತೆ next Friday ಯಾವ ತರ ಬರುತ್ತೆ ಅವ್ರು let them file ಅವ್ರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರೇನ್ ರೆಡಿ ಇರ್ತಾರೆ ಡಿಸ್ಪೋಸ್ yes
for appellant Sadashivaya KG.
Please, my lord, I represent the response 1 and 2 is in this matter, my lord. I
Yes.
filed the application for the withdrawal of the deposit made by the amount.
yes
In
Mr.
My lord, the connected appeal is also filed by me for announcement before the Sammal court.
Which is that number?
MFA 2265 of 2022. my lord.
All
It is
this
in the
matter of-
before the division bench, my lord.
then it has to go before the division bench yes
My lord.
Learned
My lord,
counsel for-
before that, my lord, I am permitted to withdraw the amount.
no there matter has to go before the division bench
Not in this matter, my lord, because
No, this
the
connected matter is there it cannot be
ma'am.
decided in before two different bench it has to be clubbed
True, my
together
lord. True, my lord. Therefore, because, my lord, since the appellant has already filed the amount and deposited the amount, my lord, the petitioner
Yes,
may permitted to
that
withdraw.
no see they are saying that dispute in respect of that liability then matter has to be heard by the division bench before ಅಲ್ಲ ಆಯ್ತಾ ಆಯ್ತಾಯ್ತು wait yes learned counsel for the respondent has submitted that the claimant has filed an appeal challenging that very same judgment and award in MFA so and so is pending before the division bench. In view of the same, the office is directed to post this matter along with the so and so. After taking necessary order from Honorable Chief Justice.
And date may kindly.
In the meantime, week's time is granted to do the needful.
Sir,
Yes.
number repeat ಮಾಡಿ sir.
Sadashiv number
My lord, 2265 of 2022.
yes.
22.
My date may kindly be fixed, my lord, so that I can, because in the, it
No,
is in
that
the.
no, Mr. Sadashiv, we have to move before the division bench. I can't fix that. We don't know what is
I'll-
there. Yes. Yes.
Cell number 35 urgent, cell number 36 BC Sitaram Rao for appellant Jagadish H.T. Bhargav.
Manoj, the delay may be condoned, Manoj, and TCR is required. Liability is challenged.
Yes, we'll condone the delay. 36 days delay in filing that appeal is condoned. IA 1 of 20 is allowed. Office is directed to procure TCR.
Cell number 37 urgent, admission matter. Cell number 38 Mohammed Sharif for appellant Janardhan Reddy.
Yes. ಕೊಡಿ. Suffering. Disability ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? ಹಾ 20% ಗೆ ನೀವು ವಾಟ್ ಇಸ್ ದ ಡಿಸಬಿಲಿಟಿ ಅಸೆಸ್ ಬೈ 15%? No, that you just give the figure because I have to give a reasoning. Wow, what is that disability percentage? Alala, limb disability 90. Yes. 20% you have assessed. Yes. Then income. 12,000. Income tax returns file ಮಾಡಿದಾರಾ? What is that exhibit? No, exhibit I must. P18, 19, 20. Yes. 12,000 ತಂದಿದ್ದೀರಾ. What is his age, Mr. Reddy? Yes. Disability, pain and suffering ಎಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ? Pain and suffering 60. Three months ತಗೊಂಡಿದ್ದೀರಾ? ಇಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಕೊಟ್ಟಿಲ್ವಾ? ಲಾಸ್ ಆಫ್ ಅವರು Yes. Disability ಅಂತ ಏನೋ ಒಂದು ಕೊಟ್ಟಿದಾರಲ್ಲ ಅದಿಲ್ಲ ಅದು yes that will not be. Immunities ಗೆ 20ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ 50 ಮಾಡಿದಿರ ಒಟ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರಲ್ಲಿ ಅಡಿಷನ್ ಇದೆಯಾ ಫುಡ್ ಅಂಡ್ ನರಿಶ್ಮೆಂಟ್ ಆಮೇಲೆ ಇದೇ ಆದಿದು ಫ್ಯೂಚರ್ ಅದನ್ನೇ ಮೇಂಟೈನ್ ಮಾಡಿ so and so learned council appearing for climate has contended that due to that accident climate has suffered previous injury. He has examined the doctor. Doctor has assessed the disability of 90%. The tribunal has not assessed any disability and has not granted any compensation under the head of loss of income during the later period. She further contended that the climate is paying climate is an income tax assessee. He has produced income tax returns for period of 2000 ಯಾವ year 2005 6 and 7 and 8. The tribunal has not considered the same as assessed notional income of rupees 8,000 is on lower side. She further contended that due to the accident climate has suffered grievous injury, was inpatient for a period of 17 days. He has suffered a lot of pain during the treatment. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri Reddy Learned Council appearing for insurance company has contended that even though doctor has deposed that climate has suffered 90% disability, tribunal has considered that evidence of doctor and injury suffered by the climate has rightly held that the climate has not suffered any loss due to the disability. Hence, tribunal has not granted any compensation under the head of loss of future earning. He further contended that considering that documents produced by the climate and considering that evidence of climate has rightly assessed the monthly income of the climate as 8,000 per month. He further contended that considering that evidence of doctor and injury suffered by the climate, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Climate has suffered an injury in a road traffic accident occurred on 24/1/2009 due to rash and negligent driving of driver of lorry bearing registration number AP27 X5659. Due to that accident, climate has suffered the following injury. Doctor Alvin has examined as PW2. In his evidence, he has deposed that the climate has suffered 90% disability. Considering that evidence of doctor and injury suffered by the climate, I am of the opinion that the whole body disabilities can be assessed 20%. 15, yes, 15%. Whole body disabilities can be assessed 15%. The climate has produced income tax return as per Exhibit P8, 9 and 10. Considering that income tax returns, I am of the opinion that the monthly income of the climate can be assessed 12,000 per month. 18, 90, 20, 21. At the time of the accident, what was his age? 46 years. The multiplier applicable to that age group is 13. Accordingly, loss of future earning has been reassessed as follows.
That's 80,000. We can break.
Yes. Due to that accident, claimant has suffered the following injury. Was inpatient for a period of 17 days. Has suffered lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, and inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of income during the later period for 3 months. Loss of amenities has to be enhanced from 20,000 to 50,000. The claimant is not entitled for compensation under towards disability ಇದೆಯಲ್ಲ ಅದನ್ನೇ loss of income during the later period. ಇಷ್ಟೇ ಅಲ್ಲ, the compensation awarded in other head and just reasonable. Accordingly, the appeal is disposed of.
Number 39, Streamin Madhusudan for appellant, Vijay Kumar.
My lord, I am for the respondent, my lord.
Ready, Mr. Vijay Kumar.
Please.
Yes, Mr. Kumar. ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, ಮಾಡಿದಾರ? ಎಷ್ಟು? Why tribunal has not considered? Where is that? ಎಲ್ಲಿದೆ? ಡಾಕ್ಟರ್ ಡಿಸ್ಕಷನ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್. Why? Yes, Mr. Vijay Kumar, why that?
My lord, she is a teacher, assistant teacher in a government pre-university college, continuing service and getting regular income, my lord. Another 50,000 may be awarded.
Yes, you are continued in that service.
Yes.
Then, yes, in addition to that, other 50,000 he is agreeing, will dispose of. Double that amount which is granted by the tribunal. Pain and suffering go 25 ಕೊಟ್ಟಿದ್ದಾರೆ. What are the injuries? ಎಷ್ಟು major injuries ಇದಾವೆ?
2 injuries, my lord.
2 fractures. 40 50. 25. ಮತ್ತೆ towards 25, 50. ಕರೆಕ್ಟ್ ಹೇಳಿದಾರೆ. 50,000. 25,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಲ್ಲಿ. ಇನ್ ಅದರ್ ಹೆಡ್ 25,000, 50,000 ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತು. ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ರಿಮೂವಲ್ ಆಫ್ ಇಂಪ್ಲಾಂಟ್ 30,000 ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ 15,000, 25, 10, 30, 40,000 ಆಯ್ತು. ಇನ್ನು 10,000 ಹೇಳಿರೋದು ಜಾಸ್ತಿ ಇದೆ. ಗಿವ್ ಮಿ ದಟ್ 60,000 rupees.
2010 accident.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ
No, my lord.
60,000 ಮಾಡ್ಬಿಟ್ಟು. Yes, yes, ಹೇಳಿ. So and so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous injury. Doctor has deposed that claimant has suffered 12%, 37.3% disability
To the limb.
to that limb, and claimant has suffered. She has suffered grievous injury and suffered lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. The overall compensation awarded by the tribunal is on lower side. And she sought for enhancement of compensation. Shri D. Vijay Kumar, learned counsel appearing for insurance company, has contended that even though doctor has assessed the disability, since the claimant has continued in his service, there is no loss of income due to the disability. Therefore, tribunal has rightly not granted any compensation under that head. if he further contended that, considering that injury suffered by the climate, considering her age and avocation, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. Climate has suffered an injury in a road traffic accident occurred on 12/8/2010 due to rash and negligent driving of driver of either TVS, which is that auto bearing registration number KA09B2298. Due to that accident, Climate has suffered the above said injury. She has examined the doctor as PW2. In his evidence, he has deposed that Climate has suffered 37.5% disability to particular limb. Since she has continued in her service, there is no loss of income due to the disability, but she has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the Climate, I am of the opinion, in addition to the compensation awarded by the tribunal, 60,000 has been awarded with 6% interest. Accordingly, the appeal is disposed.
Much obliged.
Number 40 adjourned. Number 41, Maruti GB, MK Niyazuddin for appellant, GP Sitaram Rao.
Yes, who is that Maruti GP? Nobody orders it last week. Pass over, let us.
Number 42 adjourned. Number 43, Suresh Lathur for appellant, Priyanka Reddy.
Yes, Mr. Suresh.
Serial number 43, Suresh Lathur.
You want time?
Mic mute ಆಗಿದೆ sir.
Next week. Yes, he wants time one week, Mr. Suresh.
My lord, I am ready, my lord.
Yes, Mr.
I am ready, my lord, in this case.
Yes, he wants next week. Reddy wants next week. Yes, release this matter next week.
Number 44, Ravi Raman for appellant, connected matter, Savita Kulkarni. This is Shivanegoda.
Yes, Mr. Hiraman. Manager of Sri Ram General Insurance Company. Insurance company is where is Gowda? Idral ಅವ್ರಿಗೆ get notice. Pass over. Get him. We'll dispose of. You are appearing for the owner. Why? Permit illa anta. Is there permit is? Yes, where is that Gowda? Pass over. Get him. Pass over. Pass over.
Number 45, Mahesh are looking for appellant, Chiranjeev Ram, D. Ramakrishnan.
Yes, Mr. Mahesh is not there. We'll admit it. Yes, how to admit.
Number 46, Ananda Shetty for appellant, K.V. Satish Chandra.
Yes, it is owner's appeal. What is that? What is the covered? What they said? ಏನಂತ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ? Yeah, that Rani's case has been considered. Yes, he wants time next week. Yes, let us see. We'll see that. Yes. Yeah, which is that serial number? 40? 46 2020 ಇಂದ ಇದೆ. ಏನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಈಗ? ಅವರೇ ಇಲ್ಲಿ ಇದ್ದಾರಲ್ಲ ಅಲ್ಲಿ. Are you pursuing that execution? Then we'll stay. Have you deposit 50%? 25,000 it's a statutory deposit. If you want to stay, I will grant that subject to deposit. Or you wait. Anyhow, he is not pursuing that. ಇನ್ನು 50,000 ಕಟ್ತೀರಾ? ಅಯ್ಯೇ ಎಲ್ಲಿದೆ? ಅಯ್ಯೇ ಇದೆಯಾ ಸ್ಟೇಗೆ? ಯು ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಸ್ಟೇ. Application. You have not filed, mister.
Additional document.
You have not filed, yes. Yes, at the request of R1. Request of R1. Release this matter next week. Yes, call for records.
47, Vetanand for appellant, DS Sridhar.
Vetanand. Yes, Sridhar. Password Sridhar. Extension of interim order of the stay. ಏನಿದೆ? ಸರಿಯಾಗಿದೆ.
ಮಂತ್ಸ್ ಕೊಟ್ಟಿದ್ರು 12 13 12 ಇನ್ನೂ ಇದೆ ಸರ್.
21 ಕೊಟ್ಟಿದ್ರು. Interim order IA1 of 2022 order the learned council for the parties. Interim order granted 13/12/2021 is extended till next date of hearing. IA1 of 2022 is disposed of. Accordingly, IA1 of 2022 is disposed of. Heard, admit. IA2 of 2022 will be considered at the time of hearing. Yes, Mr. Rupin. Yes. He said that it is dismissed. Then records has to come. Then he said that it will be admitted. It will come. You move that matter. All this thing. He wants that matter to be heard in that hearing. Yes, heard. Admit. Post this matter for hearing in second week of December. Yes. Let us see. First week of December, yes. Yes, branch office settled bus stand, representative branch manager as Paso. Yes, Mr. Paso, records ಇದೆ ಬರ್ಲಿ. ಅವ್ರು ಇದ್ರಲ್ಲ ಜ್ವಾಲಕುಮಾರ್ ಕರ್ಕೊಂಡು ಮಧ್ಯಾಹ್ನ. Yes, anyhow today no matter. Mohan Kumar. Paso.
My lord, 50, my lord.
Yes, yes, Mr. Mohan.
But I am here for the appellant, my lord.
What is this?
But the 163A matter, my lord, the owner himself is a tort visa. So my submission, the petition is not maintainable. 163A. He himself is a tort visa. But timeline awarded 5 lakh rupees, my lord. My lord, I have deposited, my lord, the award.
Have you deposited?
Direction of this honorable for 50%.
Car bearing.
I furnished the, my lord.
Car bearing.
10 days time can be granted, my lord. I will deposit.
In fact, yes. You have not deposited. Have you deposited that 50%, Mr. Mohan Kumar?
Yes, my lord, we have deposited 10 days time can be granted, my lord. I will furnish the appointment. 10 days.
Learned counsel for the appellant submits that as per the order dated 5/3/2021, the appellant has deposited 50% of the award amount before tribunal.
Yes, my lord. Tribunal. Yes,
Submission of learned counsel for the appellant is taken on record. Heard, admit.
Yes, sir, may be called for.
Yes, Yes,
Number
sir.
51, 52 adjourned. Serial number 53, Ashok N. Patil for appellant, R. Chandra Kumar, HR Renuka.
Yes, madam. Non-filing of acknowledgement having deposited that amount before the tribunal. Have you deposited? Yes, who is other side?
Chandra Kumar.
Learned counsel for the appellant has submitted that as per the order dated 17/12/2020, the appellant has deposited award amount before the tribunal. Submission is taken on record. How to admit? Yes.
Serial number 54, Manjula and Tejasvi for appellant, connected matter, Manjula, AVR Kamaroli.
Ready? Yes, madam. Yes. No, you have not filed any appeal. Their cross, then we'll consider. Let us see that whether why tribunal has not considered that bills. Is there any duplication? Yes. Yes. Why the tribunal has not awarded that bill? You are not produced before the tribunal. Regarding treatment expenses, 6 lakhs towards treatment, but the petitioner has produced the bill of rupees 28,000, which is not. If bill 28 ಅಷ್ಟೇ produce ಮಾಡಿರೋದು. ಕೊಡಿ. Therefore, now she is harping on that medical bill. At least they can get that compensation if it is really they have spent. No, additional bill I'll produce ಮಾಡಿ consider ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ let us see whether it is genuine or not. Pharmacy ಇದೆಲ್ಲ ಎಲ್ಲಿತ್ತು ಮೇಡಮ್? 783. ಆಯ್ತು ಅವೆಲ್ಲ 86 700 ಇಷ್ಟೇ ಇದೆ, ಅದನ್ನೆಲ್ಲ ಸೇರಿಸಿ 20. Where is that? Which is that? 1 lakh ಕೊಡಿ. ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಿ ಏನು ಫೈಂಡಿಂಗ್ ಇಲ್ಲ. ಅದರ್ ಬಿಲ್ಸ್ ಆರ್ duplication, nothing. I think the documents which is shows that only 29,000. I will call for, let us see that. Yes, office is directed to secure. Our case could you will take notice, madam. Yes. Manjula Tejaswini is directed to take notice for respondent number 3. Who is appearing for 1, 2, 3? 1, 2.
Yes.
1, 2, their owner. In your case, they are appeared as a owner, madam. Yes. Chidambara GS is directed to take notice for 1 and 2. Learned counsel for the appellant in class objection is directed to serve 1 set of copies to respective counsel. Office is directed to secure original records of the tribunal. Is it marked on that? This document is marked, madam. Then it is not brought to the notice of the court, I think. Let us see. Let the original records.
Number 55, 56 adjourned. Number 57, Yogesh DK for appellant, connected matter, Manjula and Tejasvi, MU Punacha.
Ready, madam? Yes, pass out. Yogesh GK. Huh? Out the idea, Yogesh GK. Yogesh GK is ಹಾಕಿದ್ದಾರೆ but ಅದರಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಪುನಃ your name will be shown. Yes, because you have filed an appeal in that connected matter. Yes, office is directed to delete the name of MU Punacha for R1. Show the name of Manjula Tejaswini. Internet counsel for the appellant is directed to serve one set of copies. Yes. ನಿಮ್ದ್ರಲ್ಲಿ ಫರ್ನಿಶ್ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇದು PF ಇದೆ. ಯಾರು? ಯೋಗೇಶ್ GK ಅವರೇನಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1? ಕೊಡಿ.
ಇದರಲ್ಲಿ ಸೋಮಶೇಖರ್ ಪ್ರಕಾಶ್ TM.
57.1 ಅಲ್ಲಿ Yogesh GK is directed to take notice for respondent number 1. He is undertaken to appear for respondent number 1. ಅವ್ರದ್ದು ಯೋಗೇಶ್ ಕೇಸಲ್ಲಿ ಪುನಃ ತೆಗೆದ್ಬಿಟ್ಟು ಮೇಡಮ್ ಹೆಸರು ಹಾಕಿ. Yes, office is directed to records from the tribunal.
Number 58, Nagaraja Reddy team.
Yes, Mr. What is this? Climate appeal. Notice. ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ? ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? ಆಗಿದೆಯಾ? On this matter along with that accounts. Yes.
For petitioner.
My lord, I am appearing for the petitioner, my lord. A petition filed by the insurance company for a review of the order passed by this court, only taking up the appeal of the claimant. Though I was present on that day, neither the claimant nor me placed records before the court that there is an appeal also pending by the insurance company before this court, my lord. That is only I am before this court now. I will serve a Pawan Chandra Shetty, my lord. Pawan Chandra Shetty, ನಾನು ಕಾಪಿ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇವತ್ತೇ ಕೊಡ್ತೀನಿ ಸಾಯಂಕಾಲ.
Yes.
Please.
Pawan Chandra Shetty is directed to take notice for respondent.
Respondent 1, my lord.
Why you have not brought to the notice, Mr.
It is extremely sorry, my lord. It is true, I was present before the court on the day when it was decided. But unfortunately, it was not brought to the notice of the court. There is an appeal filed by the insurance company is also pending.
No, that who is other respondents?
Owner of the vehicle and Pawan Chandra Shetty. Pawan Chandra Shetty is a claimant, my lord, who was sought for enhancement, which was allowed by the Honorable Court.
No, that you want notice to owner, it can be dispensed.
Yes, my lord.
Yes, Pawan Chandra Shetty is directed to take notice for respondent number 1. Learned counsel for the review petitioner through VC has submit that notice to R2 may be dispensed. To that effect, he will file an memo and register. Accordingly, notice to R2 is dispensed. Office is directed to show the name of Pawan Chandra Shetty for R1. Release this matter next week.
Namdu appeal 7238, my lord, of 15.
Our Burley,
sorry, sir.
then we'll say.
Aye, sir.
Yes, Mr. But what is your matter? Serial number? Serial number 3 now. Notice ಹೋಗ್ಬೇಕು. Memo will be dismissed. Yes. Yes. Memo filed for dispensation is dismissed as withdrawn. To notice to respondent number 1.
number 60 adjourned. Case number 61, Karnataka for appellant, B.V. Krishna, Neela Krishna.
Yes. Or he said that he is ready. I said, and then pass over will dispose of the matter. Yes.
Number 61, P. Karnataka.
Karnataka, pass over.
Number 62, 63, 64, 65 adjourned. Case number 66, Jaitan for appellant, connected matter, P.G. Raju.
Yes, Mr. Raju, what is this?
Yes, Govardhan.
Filed by whom? Live at. No, what is your case in this appeal? ಅಲ್ಲ ನಿಮ್ದು ಅಪೀಲ್ ಡಿಸೈಡ್ ಮಾಡಿದ್ರೆ ಅವು ಇಟ್ ಇಸ್ ಇಮ್ಮೆಟೀರಿಯಲ್ ಯು ಹ್ಯಾವ್ ಎ ಚಾರ್ಜ್ ಡಿಸ್ಪೋಸ್ ಏನಾಗಿದೆ ಅಪೀಲ್ $6603 ಬಂದಿದೆಯಲ್ರಿ ಹಾ 6603 ಆಫ್ 2013 ಏನ್ ರಿಕಾಲ್ ಆಗಿದೆಯಾ ಫೈಲ್ ಕೊಡಿ wait in spite of passing a preliminary order that shows granting a 6 times notes in view of the temporary order appeal is dismissed non-compliant. Recall ಆಗಿದೆ ಅಂತ ಕೊಡಿ 6603
ಆಗಿಲ್ಲ ಸರ್ ಆ PF ಅಲ್ಲಿ ಹಾಗೆ ಬರ್ತಾ ಇತ್ತು ಹಾಗೆ ಕನೆಕ್ಟ್ ಆಗಿದೆ
ಆಯ್ತು ಇದನ್ನ ಹೆಂಗೆ ತೋರಿಸ್ತಾರೆ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಆಮೇಲೆ
ಅವರು ಇಲ್ಲ
Where is Chetan? ಅವ್ರು ನೀವು ಇನ್ನೊಬ್ರು ಅಪೇರ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಯಾರು ಅವ್ರು ಯು ಆರ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ಹೋಮ್ ಮಿನಿಸ್ಟರ್ ನಿಮ್ದೇ ಅದು ಅಪೀಲ್ ನೌ ಯು ಆರ್ ಅಪೇರಿಂಗ್ ಏನು ವಾಟ್ ಇಸ್ ದಿಸ್ that earlier who was appearing Chetan ಅಲ್ಲ ಇವ್ರದ್ರಲ್ಲಿ ಅಲ್ಲ ಬಟ್ ಇದ್ರಲ್ಲಿ ಗವರ್ನಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಚೇತನ್ ಫಾರ್ ದ ಅಪೋನೆಂಟ್ ಫ್ರೇಮ್ ಫಾರ್ ವೀಕ್ಸ್ ಟೈಮ್ ಅಂತ ಹೇಳ್ತಾರೆ 66.3 ಅಲ್ಲ ದಿಸ್ ಕೇಸ್ ಯುವರ್ ಕೇಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ಮಿಸ್ಟರ್ ಅಲ್ಲ ಯು ಸಿ ಯು ಕೆನಾಟ್ ಡಿಸ್ಮಿಸ್ 10 October 2014 ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. There is no application for recall. I don't know how it is posted. Again, on 10/2/2022, this court has granted a last chance and learned counsel for the complying that office objection 1 week, failing to do so, shall result in appeal being dismissed for non-prosecution without further reference to this court. Dismissed case hang connect ಆಗ್ತಿದೆ. Pass over. Otherwise, this will go, Mr. Recalling ಇಲ್ದಾನೆ ಪೋಸ್ಟ್ ಆಗಿದೆ, ಇವರು NOC ಹಾಕಿದ್ದಾರೆ, ಮತ್ತೆ ಇನ್ನೊಂದ್ಸರಿ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಆಗಿದೆ. How that office has posted? Pass out.
I appear for the appellant in these two cases, and
What is
these two appeals are filed by the insurer on the issue of negligence and also quantum. Quantum in view of 5,000 income is taken. Future prospects ಮೇಲೆ our cross objections allow ಆಗಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ, first you argue on that negligence. If there is no point on negligence, then you will see that quantum.
My lord, the accident occurred.
Yes.
On 1/2/2009.
Yes.
Date of the accident.
Yes.
1/2/2009. The
Yes.
Two motor vehicles are involved. One is motorcycle number KA42E85. And another is tractor trailer KA05T3702 and 1012. I am the insurer of the tractor. The trailer was uninsured. The charge sheet is against the driver of the tractor.
Yes.
The rider is one Prakash, and the pillion rider is one Anwar Pasha.
Yes.
The rider Prakash dies in the accident on
Yes.
account of injuries.
Yes.
Anwar Pasha is examined as PW2, and he is not let in any evidence. Only medical records technician is produced.
Yes.
My lord, I am the MACT comes to the conclusion that the accident was due to the negligence of the driver of the tractor trailer. However, trailer was uninsured. I had insured only the tractor. So I took up a contention that I will not be liable. However, the MST fixes negligence at 70% on tractor and 30% on trailer. Since it was uninsured, it is 30% is ordered to be paid by the owner of the trailer.
Yes.
That's all. That I had challenged 50-50 ಮಾಡಬೇಕಾಯಿತು ಅಂತ ಹಾಕಿದ್ದಾರೆ, but I have no much
Yes.
evidence.
Why they have held that tractor is also trailer is how it is accident has occurred?
Accident has occurred. There are different versions, my lord. One they say tractor tire puncture ಆಗಿತ್ತು, ಇದಕ್ಕೆ ಹೋಗಿ ಇವರು ಹೊಡೆದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. I will just read out my lord.
Yes, you read that issue number 1.
Just a minute.
Yes.
Para 11 in the ಓದಿದ್ರೆ ಸಾಕು.
Yes.
On the other hand, that is the comparative the accident. On the other hand, senior assistant of New India Assurance Company Limited, Chidambaram, is examined as RW1. He has filed affidavit in lieu of examination chip. Along with objection, insurance company has produced the policy and same is marked as exhibit R1. RW1 has produced the authorization letter. RW1 has admitted that the head-on collision has taken between the tractor and the motorbike. The relevant portion of cross-examination of RW1 reads as follows. Tractor and motorbike ನಡುವೆ ಮುಖಾಮುಖಿ ಅಪಘಾತ ಸಂಭವಿಸಿದೆ ಎಂದರೆ ನಿಜ. Further, it is admitted motorcycle and tractor were damaged and trailer was not damaged in the accident. ನಿಶಾನೆ P3 IMV ವರದಿಯಲ್ಲಿ ಮೋಟರ್ ಬೈಕ್ ಮತ್ತು ಟ್ರ್ಯಾಕ್ಟರ್ಗೆ ಜಖಂ ಆಗಿರೋ ಬಗ್ಗೆ ನಮೂದು ಇದ್ದು, ಟ್ರೇಲರ್ಗೆ ಯಾವುದೇ ಜಖಂ ಆಗಿರೋ ನಮೂದು ಇಲ್ಲ ಎಂದರೆ ನಿಜ. On perusal of exhibit P1 FIR, it could be seen that accident has taken place on 1/2/2009 at 8:15 p.m. Statement of PW2 has been recorded by the police between 22:30 and 23:30 hours at Kanakpura Government Hospital, and the case has been registered under section 279, 337, 304A. It is stated by PW2, ರಾತ್ರಿ ಸುಮಾರು 8:15 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಬರುತ್ತಿರುವಾಗ ಸಾತನೂರು ಕಡೆಯಿಂದ ಒಬ್ಬ ಟ್ರ್ಯಾಕ್ಟರ್ ಚಾಲಕ ತನ್ನ ವಾಹನವನ್ನು ಅತಿವೇಗ ಅಜಾಗರೂಕತೆ ನಡೆಸಿಕೊಂಡು ಬಂದು ಡಿಕ್ಕಿ ಹೊಡೆದ ಪರಿಣಾಮ ಬೈಕ್ ಅನ್ನು ಓಡಿಸಿದ್ದ ಪ್ರಕಾಶ ಮತ್ತು ನಾನು ಕೆಳಗೆ ಈ PW2 is Anwar Pasha, he was the pillion raid, ಕೆಳಗೆ ಬಿದ್ದು. Exhibit P2 Mahazar is drawn in the presence of Panchas. It recorded that ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಸುಮಾರು 120 ಅಡಿ ಅಂತರದ ಉತ್ತರದ ಕಡೆ ಎಡಭಾಗ ಮತ್ತು ಟ್ರ್ಯಾಕ್ಟರ್ ನಿಂತಿದ್ದು, ಮಧ್ಯಭಾಗ ದೊಡ್ಡ ಚಕ್ರ ಬಲಗಡೆದು ಪಂಚರ್ ಆಗಿರೋ ನಿಶಾನೆ ಇತ್ತು. ಈ ಚಕ್ರದ ಮಡ್ಗಾರ್ಡ್ ಮೇಲೆ KA05T3708 ಅಂತ ನಂಬರ್ ಇರುತ್ತದೆ. Exhibit P3 motor vehicles report discloses tractor rear side wheel damage and rear side mudguard damage. Nowhere in Exhibit P3 IMV stated trailer was damaged. Exhibit P6 is a charge sheet filed against one Ananda, who is driver of the tractor and trailer. It is stated tractor and trailer caused the accident. Learned counsel for respondent 1 company vehemently argued the tractor was not involved in the accident. It was a trailer which was involved in the accident. As such, R1 is not liable. On perusal of the oral and documentary evidence, nowhere PW has stated the trailer hit the motorcycle. He has specifically and categorically stated that tractor hit the motorcycle and caused the accident. Exhibit P14, MLC extract of the complaint produced by PW3 Kim's Hospital mentions that when petitioner was hit by a tractor, he fell on his right side. While under treatment, immediately after the accident, PW2 had no occasion or intention to say falsely the tractor hit the motorcycle. At the point of time of PW2 was not aware of the legal consequences. It certainly trailer had hit the motorcycle, he would have stated the same before the doctor. Even the rough sketch discloses there was head-on collision. In the absence of materials before the court, a false claim or fictitious claim made by the first respondent, the trailer hit the motorbike, is unacceptable. On the other hand, RW1 has admitted that the accident occurred due to the motor and tractor 1 have discussed. In the light of the above, the answer is issued in the affirmative. Issue number 1 ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ, whether the tractor and trailer dashed again, the issue is cast as though tractor and trailer were both responsible for the accident. May I read para 23? Trailer ಮೇಲೆ ಯಾಕೆ 30% ಮಾಡ್ಯಾರ?
Yes.
The first respondent has admitted the validity of insurance at the time of the accident as the tractor bearing number KA05T3708 is concerned and the policy is marked at Exhibit R1. Second respondent Tibbegowda is dead and his LRs A to D are brought on record. It is admitted at the time of the accident, Tibbegowda was the RC owner and after his, it is transferred in the name of LR2C Nagaratna. Thus, at the time of the accident, there is valid insurance to a tractor. Respondent 3 is the owner of the trailer. Learned counsel appearing for respondent 1 has produced a citation reported in ILR 1996-2157 in case of Oriental versus Chandrasekharan. I have gone through the said citation. It is held that the trailer is constructed for the purpose of carriage of goods, and when it is pulled by a tractor, both tractor and trailer constitute a transport vehicle, a goods vehicle. If the tractor draws a trailer and the accident is caused by such tractor dash trailer, then the vehicle causing the accident would be tractor alone, but it is tractor and trailer. In the instant case, tractor was with trailer when the accident occurred. The oral and documentary testimony clearly established tractor has hit the motorcycle and not the trailer. Keeping in mind the above citation, it is considered tractor trailer has caused the accident. Tractor is insured with the first respondent, trailer is not insured. Hence, respondents 1 and 2 being the insurer and owner of the said tractor are held jointly severally liable to 70% and compensation amount to the petitioner. Third respondent being the owner is liable to pay remaining 30%.
No, that nobody's case is that tractor has hit trailer. If the tribunal himself has taken that it is a trailer. Trailer is
ಅದು ಆ ಡಿಸಿಷನ್ ನೋಡ್ಬಿಟ್ಟು ಟ್ರಿಬ್ಯುನಲ್ has swayed away by that decision.
No, that tribunal, that decision, tractor and trailer, if together it will be a goods vehicle. They have not said that tribunal ಅದನ್ನ interpret ಮಾಡ್ಬಿಟ್ಟು therefore it is in a trailer. That cannot be.
ಹೌದು.
Then what is that their case?
ಅವ್ರ ಕೇಸಲ್ಲಿ ಕ್ವಾಂಟಮ್ ಒಂದು ಹೇಳ್ಯಾರ ಅಷ್ಟೇ. ಅವ್ರು ಕ್ವಾಂಟಮ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. Accident is 2009.
Yes. Satish.
Future prospects I saw a 2009.
Luckily, error in taking considered income. The error in awarding a meager sum of rupees. Loss of estate. Tribunal has taken considered the income of honorable tribunal has error in holding the third response owner is. They have also challenged that 30% liability.
I saw a 20
Yes.
On 35 years, so it has future prospects add.
No, first case is the death case.
How though? Yes, 1440.
1446.
46.
Page number?
Just a minute. Page number para 13 of the judgment, my lord.
Yes.
Running page 23. It is contended that the petitioner, the deceased Prakash was aged 31 years at the time of the accident, was working as coolie and vending milk, earning 250 per day, 7,500 per month. Petitioners have not produced any records to the effect. In the course of cross-examination, it is denied suggestion that the accident was aged more than 35 years. It is admitted that in P7 ration card, the age of the deceased is mentioned as 37 years. Exhibit P5, PM report mentions the age 35 years. The learned counsel of the petitioner has relied upon the citation reported in 2012 ACJ, that is Santoshi Devi's case, ACJ 1428, and argued that the salaries of government service and those employed in private sector get increased, but it cannot be denied there has been implemental enhancement in the income of who are self-employed, and even if the cost increases, the price essentials goes up. Adhan discuss ಮಾಡ್ಯಾರ ಅಷ್ಟೇ. So there will be
30% increase in the total. 30% ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ average 5,000 ತಗೊಂಡ್ಯಾರ ಅಷ್ಟೇ. Last
5,000. No, that 30% have they added for future prospects?
Yes. The last 4 lines, man. Hence, even in the case of future prospects is taken into consideration, the monthly income of deceased is taken as 3,000 per month. As per PM report, deceased was aged 35 years. Deceased would have lived another 45 to 50 years, would have earned 7,000. Hence, the average income is deceased has taken as 5,000. 3,000 ಅಂತ ಕಂಪ್ಯೂಟ್ ಮಾಡ್ತಾರೆ, ಮತ್ತೆ 2,000 ಸೇರಿಸ್ತಾರೆ.
No, ಅಲ್ಲಿಗೆ income has to be taken 5,000 and 40%.
ಹೌದು.
40% has to be added.
Yes.
Then other head. What about that in another case?
Adರಲ್ಲಿ, of course, it is a case of injuries. No doctor evidence ಏನ್ ಮಾಡಿಲ್ಲ. ಅದು ಬರೀ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ರೈಟ್ ಫಿಬುಲಾ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದರಲ್ಲಿ he says that he was working.
Who is that Satish?
Company Ramesh and Satish ಅಂತ ಇದ್ದಾರೆ.
ಬರ್ತಾರಾ?
ಬರ್ತಾರೆ ಕೋರ್ಟ್.
No, we'll pass it over. Let us see. We'll dispose of. That is one.
ಮಾಡ್ಬೋದು.
Madhyana, I will held 100% negligence.
ನಮ್ಮ ಮೇಲೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಹಾಕಿ ತಗೊಂಡ್ ಮಾಡ್ಬೋದು.
Dispose ಮಾಡಿ. No, if you know him, just inform him.
ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೆ. ಇಲ್ಲ, ಡೆಫಿನೆಟ್ಲಿ I'll help.
Yes.
Interest 8% ಕೊಟ್ಟಿಯಾರ, 6%.
That will reduce. Yes. Yes, madam. Very. Serial number? Yes, Mr. Shivanagowda, have you seen the records? Permit is there. ಅಲ್ಲ, ಅವ್ರೇನೋ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತಿದ್ದಾರೆ. ಪರ್ಮಿಟ್ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ನೋ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. ಡಿವಿಎಸ್ ದಾವಣಗೆರೆಯಿಂದ No, where is the finding? Which is the paragraph?
17.
Para 17. Respondent has taken a contention according to the extract disclosed that auto rickshaw is transport vehicle, driver who drives the transport vehicle, he must have any badge driving that license also. Transport vehicle, driving license, drive non-transport vehicles, the learner principal at the time of the effective driving license. So accordingly, no, this is regarding that transport. Adalla, where is that this thing? Yes. No, then the case is that there is no permit. Now he is producing the permit. That's what I asked, that whether you have verified. Therefore, I have. He said that I have furnished you. Therefore I asked, get Gowda whether he has. No, but now that he verified. No, Gowda, now verify. If it is there, then you have to be reverse that judgment. That's all. Next week. That is the only point. Yes, now you have furnished it before me. Now we can't say no. Yes. As long as this subject is before this bench. Yes, normally Gowda will not do that. Let us see. Yes. Yes, when you. Yes. Yeah, you want any particular date next Friday? Yes. Yes. No, Hiremat has to come for this case only. This is the problem. Eh? You are regularly there now in that Dharwad. Ask. Aditra, he will concede. Anyhow, let Hiremat come. Let him come once in a while to the High Court. Let him see that. Yes. Yes.
Number 68 adjourned. Number 69, Suresham Lathur for appellant.
60.
59.
Yes, Mr. Suresham Lathur. Afternoon. 2:30. Yes, none appear for the appellant. We release this matter next week. Yes, Mr. Raju, you have any matter? '66 we passed Madhyana, 2:30. Yes, Mr. 20. Mahesh or Madhyana barbod nodan. Yes, afternoon.
What up, sir? What up, sir? What up, sir? What up, sir?
ಯಾರು ಕೇಳ್ತಾರಲ್ಲ
ಹೇಳಿ ಸರ್.
Serial number 32 ಏನಾಯ್ತು ಸರ್?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Okay, thank you.
ಓಕೆ.
ಇದು
ಒಂದಿದೆ ಅಷ್ಟೇ ಪಂಜಾಬ್
Whatever matter, which number?
Yes. 49. Yes. At the request of the parties, release this matter next Thursday.
Whatever matter, list number 2, serial number 2, Raghavendra K. for appellant.
Yes. Raghavendra K. Okay.
Presentation will be long. There are no office objection.
They have not complied the office objection. Who is that counsel, Raghavendra K? You are no? On 24/8/2028, this court has granted 2 weeks time to comply that office objection. Again, on 7/2/2022, 4 weeks time is granted to comply that office objection. Even today, office objection is not complied. Today, the matter is posted for non-compliance of office objection. When the matter is called twice, none appear for the appellant. It appears that the appellant is not interested in prosecuting the case, hence dismiss for default. Let us see.
Number 13, Kavita HC for appellants, Ravish Benny.
Serial number 30.
30.
Yes, who is that? Kavita? Let's see. They're not- Hmm. 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 Where is that? Our colleague ಯಾರೋ ಒಬ್ರು ಇದ್ರಲ್ಲ ಇಲ್ವಾ ಅವರು? Somebody is ready. He is there, you get him. Dispose of. Pass on. Yes.
Abdul Sabur for appellant, O Mahesh.
I am for the appellant in this case, my lord.
Yes. Notice to R1 and R2 is dispensed. Records beka? Office
No,
is
sir.
direct.
Not necessary, my lord.
Yes, next week. Notice to 1 and 2 is dispensed at the risk of the appellant. We will this matter next week.
Number 32, English entity for appellant, yes, Suresh.
In this case, I appear for respondent number 3, my lord. Pray for some time. They have filed an amendment application. Therefore, I pray for some time, 2 weeks time may be client.
What is that amendment you sought? No, that is the ground that in view of that, no, that will not survive for consideration. It is not necessary because they said that in view of the Mukund Devagan case,
yes,
it is covered. That even if he is not filed an application, it can be considered. It's a question of law.
ಅಲ್ಲ ಪೇಪರ್ಸ್ ನಂತರ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಒಂದು 2 weeks ಟೈಮ್ ಸ್ವಾಮಿ.
ಯಾರು
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ಲ, ಓನರ್ ಮೇಲೆ ಆಗಿದೆ, ನಿಮ್ ಮೇಲೆ ಎಕ್ಸಾಮಿನೇಟೆಡ್ ಆಗಿದೆ. Now in view of that Mukund Devagan case, it is covered. You verify next week.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದು ಪೇಪರ್ಸ್ ನನ್ಗೆ ಏನ ಕೊಟ್ಟಿದ್ದು ಬಂದಿಲ್ಲ.
Now that they have furnished with your colleague.
Yes, ma'am.
Yes. Next week. Yes, next Thursday.
Number 41, Maruti GP for appellant, this is Sitaram Rao.
Yes. Yes. As he continued in this service, where is that evidence show that he has not continued, Mr. Considering that injury sustained petitioner some so and so, that towards 8,000 petitioner has produced some CAD and bus tickets. Petitioner is stated in his evidence that he has taken a treatment 9 days. Claim to be compensated for loss of immunities in that instant case. Petitioner has claimed the compensatory loss of earning during the period of treatment. The present CAD petition sustained partial permanent disability on the account of injury sustained. Thus, he is not entitled for any compensatory loss of earning capacity, future loss of earning capacity. He is not entitled for any compensation under this head. For the said reason, the claim of petitioner is partly annulled. Why he is not entitled? What is your case evidence? What is the doctor said? What was he earlier? Have you produced that any documents? ಎಷ್ಟು ಡಿಸಬಿಲಿಟಿ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ? ಹಾ, ಡಾಕ್ಟರ್ ಮಾಡಿದೀರಾ ಇಲ್ವಾ ಫಸ್ಟ್? ಏನು ವಾಟ್ ಇಸ್ ದ ನೇಮ್ ಆಫ್ ದ ಕ್ಲೈಮೇಟ್ ಮಿಸ್ಟರ್? ಎಲ್ಲ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲಲ್ರಿ. HK ರಾಜು 30 ವರ್ಷ ಗಾಯಾಳು ಈ ಕೆಳಕಂಡಂತೆ ಇರ್ತದೆ. ಪರೀಕ್ಷೆ ನಡೆಸಿದಾಗ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡ್ತೀನಿ, ಈಗ ನನಗೆ ತೋರಿಸಲಾದ ದಾಖಲೆ ಈಗಲೇ ಅಂತ ಗುರುತಿಸಿ ಅಷ್ಟೇ. ಡಾಕ್ಟರ್ ಏನು ಹೇಳಿಲ್ರಿ, ಗಾಯ ಆಗಿದೆ ಅಷ್ಟೇ. ಆಯ್ತ್ರಿ, ನೀವು 1, 2, 3, 4, 5 ಜನಕ್ಕೆ ಒಂದೇ ಸಾರಿ ಡಾಕ್ಟರ್ ನಿಲ್ಸ್ಬಿಟ್ಟು ಸ್ಟೇಟ್ಮೆಂಟ್, ಹೌ ಕ್ಯಾನ್ ಯು ಗಿವ್ ದಟ್? 5 ಜನಕ್ಕೆ ಒಂದೊಂದು ಪ್ಯಾರ ಹೇಳ್ಕೊಂಡು ಬಂದಿದ್ದಾನು ಅಷ್ಟೇ. ಸೊ ಅಂಡ್ ಸೊ ಇಂಜುರೀಸ್, ವೇರ್ ಇಸ್ ದಟ್ ಎವಿಡೆನ್ಸ್? Disabilities is not. How can you say that? No, that has to be supported by evidence of doctor. Nothing is there. No, Mr. It is nothing but there is no evidence of doctor. He said you have suffered 6 injuries. That's all. He has never said because of the disability you can't do this work. Then tribunal rightly has said. ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರ್ರಿ ಡಾಕ್ಟರ್ ಹಂಗ್ ಬಂದ್ಬಿಟ್ಟು ಒಳ್ಳೆ ಇದ್ರ ತರ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ನು ಸುಮ್ನೆ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲಾರ್ದು ಇದನ್ನ ಮಗ್ಗಿ ಹೇಳ್ದಂಗೆ ಹೇಳ್ಕೊಂಡು ಹೋಗಿದಾರಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಮಿಸ್ಟರ್? ಇಟ್ಸ್ ಎ ಸೀರಿಯಸ್ ಕೇಸ್. ಹೌ ಕ್ಯಾನ್ ದಟ್ ಡಾಕ್ಟರ್ ಸೇಸ್ ಕಮಾಂಡ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ದಟ್ ಎಸ್ ಕುಸುಮಾ ದಿಸ್ ಆರ್ ಇಂಜುರೀಸ್, ರಮೇಶ್ ದಿಸ್ ಆರ್ ಇಂಜುರೀಸ್? ಏನಿದೆ ಅಟೆಂಡೆನ್ಸ್? It shows that how he is doing the profession. Yes, nothing is there on that records. ಏನಕ್ಕೆ? Who has to say, Mister? Either you or me. Injuries ಇದೆ, injuries ಎಷ್ಟು ಕೊಡಬೇಕು ಅಷ್ಟನ್ನು ಕೊಡಬಹುದು. That is all. That the loss of future earning you are not entitled because there is no evidence at all. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 39,000. Where is that Anup? Where is other side? So if he comes, we'll see. Otherwise, we'll refer to that Lok Adalat. Why? How much you have demanded? ಅಲ್ಲ, ಎಷ್ಟು ನೀವೇನು ಅವ್ರು ಹೂ ಅಂತಾರೆ, ನೀವು ಒಪ್ಕೊಂಡ್ಬೇಕಲ್ಲ. ಎಷ್ಟಕ್ಕೆ? 1,20,000 ಎಲ್ಲ ಐತ್ರಿ ಇಂಜುರಿ ಲಾಸ್ಟ್. ಆಯ್ತು, ಅವ್ರು ಬಂದ್ರೆ ನೋಡೋಣ. ಪಾಸ್.
Number 48, Kala Young for opponent.
Yes, who is that? Hard, admit.
Number 61, Karnataka for opponent, V. Krishna, Sila Krishna.
Who is that council member? Karnataka. 61. ಅದೇ ಯಾರದು? Sila Krishna. Yes, none appear for the respondent. Release this matter after 2 weeks. Let us. They are not some because their presence is necessary. Yes. You are appearing for the owner. Yes, then climate has to establish their rights.
Number 66, for opponent, connected matter, PB Raju.
1 of 14, 2 of 14 ತೋರಿಸಿದ್ದಾರೆ ಸರ್ ಕೆಳಗೆ. ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್, ರೀಕಾಲ್ ಆಗಿಲ್ಲ. Delay in filing the recalling application as well as recalling the other.
Yes, who is appearing for that? Mr. Rajaram. Delay condoning what? Again, IE and Takat Badan, pending and Takat. As they shown on that day when it is posted. ಮತ್ತೆ ಅವತ್ತು ಹಾಕ್ರಿ ಅದು ಕಂಡಮ್ ಮಾಡಿದ್ರೆ ಅವತ್ತೇನು ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅವರೇ ಹೇಳ್ತಾರೆ ಈ ಮ್ಯಾಟ್ರಿಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಈ ನಂಬರ್ಗೆ ಆರ್ಡರ್ ಅಪ್ಲಿಕಬಲ್ ಆಗುತ್ತೆ ಅಂತ ನಂಬರಿಗೆ ಈ ನಂಬರ್ ಹಾಕಿ ಮಾಡಿದ್ದಾರೆ ಇನ್ನೊಂದು ಹಾಕಿಲ್ಲ ಈ ಕೆಲಸ ವಾಟ್ ಇಸ್ ದಿಸ್ MFA 6603 ಇವ್ರು ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ Planet Council for to comply that officer. There are 2 office objections and the same is not appeal is barred by time and the no application for condonation of delay has been filed. Either on application for recalling a delay rather. Then we have not complied that office objection on IA. IML application office objection recalling application. Time is granted as a last chance. Learned Council comply that office objection in 1 week. Failing to do shall stand. Yes. Subject to complying that office objection. Time has granted. Have you complied that office objection? IFR what? I3 restoration appeal ಮಾಡಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ನೀವು ಮೇನ್ ಅಪೀಲ್ದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಮಾಡಕ್ಕಿಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಇಟ್ಸ್ ಡಿಸ್ಮಿಸ್ ಸರ್ ಟೈಮ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ದ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಟು ಕಂಪ್ಲೈ ದಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ 1 week failing to do shall result in appeal being dismissed for non-prosecution without further reference to the court. Then it has to be dismissed now. What is this, Mr.? Where is your colleague, Mr.? Dismissal order recalling dismissal. What is this, Mr.? Yes, what is this, Mr. Chetan? What is this matter? Enhancement in huh? Is it, Mr.? Our the appeal kodi 6475 kodi 6475 illide ಇದು 6603 MEC 293 ಇಲ್ಲ ಬೇರೆ ಬೇರೆ ಇದೆ ಮಿಸ್ಟರ್ ಇದು MEC 293 ಮಿಸ್ಟರ್ ಜಗದೀಶ್ ಇಟ್ಸ್ ಎ ಡಿಫರೆಂಟ್ ನಿಮ್ದು ಅಪೀಲ್ ಏನಕ್ಕೆ ಏನಾದ್ ಬೇಕು ಈಗ ಅಷ್ಟೇ 293 liability no that Mr. Chetan this your appeal is 293. It's a separate order. Then this appeal is 1967. There are 2 different judgment. Is it? Putraju. Usually, your case is a case of injury. He is for a death case, but is it the same accident or a different? Originally pending so and so, the claim petition came to be transferred to and so. Accordingly, and this case petitioner 18/8/2009 18/8/2009 Sanjay Sumar Arjidar Abdul Jazim ondige Abdul Jazim was going on the motorcycle so along with his Putraj. Yes, same. 2 different award has been passed. Same accident. But you have filed an appeal in 1 case, Mr. How can you that? If we are not challenged others, when yes, according to the petitioner, he was going on a motorcycle bearing safe along with his Putraj so and so met with an accident. According to the driver of the tractor. You are appearing for the tractor and trailer. Then it is your appeal out for Jagdish. TP Raju 2921.
2921.
Yes. ಯಾ ಇದು ಇನ್ನೊಂದು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವ್ದು? ಅಲ್ಲ ಅವ್ರು ಯಾರಿಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು? ಬರೀ ಟ್ರಾಕ್ಟರ್ ವಾಹನ ಅತಿ ವೇಗವಾಗಿ ಅಜ್ಜೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ಬೈಕಿನ ಸಮೇತ ಕೆಳಗೆ ಬಿದ್ದ ಸಮಯಕ್ಕೆ ಅಲ್ಲಿಗೆ ಬಂದ KL ಮತ್ತು ಮಾರುತಿ ವ್ಯಾನ್. ಎರಡ್ ಕೇಸಲ್ಲಿ ಹಂಗೆ ಮಾಡಿದಾರಾ? ನಿಮ್ದು ಯಾವ್ದಲ್ಲಿ ಪುಟ್ರಾಜು? ಈ ಕೇಸಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? Respondent 1 is liable to 50% of the compensation amount determined so and so. Petition number 2 is entitled to compensation so and so. Out of the compensation, the claim petition against the respondent 2 is dismissed. Who is 2? In the insurance company, Oriental Insurance Company, your case ali dismiss agide. Entire liability on United Insurance Company. Therefore, they have not challenged. Since your case, they are saying in that you have been exonerated, why can't be this Santa? Correct, our appeal corrected. In view of this, idralli modify as who is appearing for other insurance company? Alla nimdrali A. Ravishankar. Then A. Ravishankar is the contesting. See, in terms of this case held, you are being exonerated. Idarna full A. Ravishankar has not challenged this. ಮತ್ತೆ ಅವಾಗ ಇದಕ್ಕೂ ಅದೇ ಬರ್ಬೇಕಾಗುತ್ತೆ. Then ultimately, if that he is appearing for which insurance company? You are Oriental, United, alla? No, you are for Oriental, Mr. United India Insurance Company has not challenged this judgment. Then it is applicable to this case. Did not be going to that merit. Where is A. Ravishankar? Yes, that is the only point, Mr. Then his appeal has to be succeeded. Whether prove that motorcycle bearing notes hit by that negligence of the tractor and trailer and driver of the Maruti van. The finding that in impression that driver of both the tractor and trailer Maruti van were equally responsible to that accident. Such accident issue. Now, idರಲ್ಲಿ ಇಬ್ರು 50-50 ಮಾಡಿದಾರೆ. ಯಾವ್ದ್ರಲ್ಲಿ? ಪುಟ್ರಾಜ್ ಕೇಸಲ್ಲ, ಇವ್ರ ಕೇಸಲ್ಲೂ 50-50 ಮಾಡ್ದಂಗಿದೆ. But why it is dismissed? Claim petition against R2 is dismissed. Oriental Insurance Company. Match manager, United India Insurance Company. 4 is the written statement has not admitted the issuance of the policy in respect to the Maruti van in person. Indicated that the vehicle was insured with the response contract. As in the force against that they have not produced any evidence before the treatment to show that the policy was not held up. Respondent number 3 and 4 are jointly survey. 50-50. Either 50-50 agide, Mr. Jagdish. 50-50 agide. Compensation accordingly, issue number 2 is answered partly in affirmative. But claim petition against R2 is dismissed and tappadu. Idral nimdralla 50-50 agide. 50, then you have not challenged in this case. Three and four. Or 3 and 4. Again, judgment if that is the case, order 3 and 4 jointly and 50-50 act ಮಾಡಿದ್ದಾರೆ. Why 50-50? Insurance is there. ನೀವು ಎರಡರನ್ನು you have to go through this also, because this will be that benefit for you. If that finding is not challenged, only the Maruti van is that negligent. But either finding a libru 50-50 and I three one case your my liability then we will take that advantage if that is not been challenged and accepted by that other. But ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾನೆ ಅಂತಂದ್ರೆ ಡ್ರೈವರ್ ಆಫ್ ಬೋತ್ ಟ್ರಾಕ್ಟರ್ ಅಂಡ್ ಟ್ರೈಲರ್ ಮಾರುತಿ ವ್ಯಾನ್ ವರ್ ಈಕ್ವಲಿ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಫಾರ್ ದ ಆಕ್ಸಿಡೆಂಟ್ as such. ಆನ್ಸರ್ ಇಶ್ಯೂ ನಂಬರ್ 1 ಅಫರ್ಮೇಟಿವ್ ಅಂತಾರೆ. ಅಲ್ಲ 293 ಇವ್ರ ಕೇಸಲ್ಲಿ ಯು ಸಿ ದಟ್ ಇಶ್ಯೂ ನಂಬರ್ 1 ಪೇಜ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ 11 ಇಬ್ರು 50-50 ಅಂತ ಹೇಳ್ತಾರೆ. $50% ಕಾಂಪನ್ಸೇಷನ್ 3 and 4 ರೀ, ಇನ್ನೊಂದು 50% ನೀವು ಬರ್ತೀರಾ. One is liable to pay 50% compensation, Mr. Respondent number 1 alone is who is respondent through that vehicle in question was not used to contravention of the policy. It is respondent number 1. Nimige, yeah, why you have been exonerated in that? The respondent number 2 disputed their liability to pay the compensation on the ground that respondent 1 violated the term of the condition of the policy. Material record to show that tractor trailer in question was being used for a transportation of electric poles. The policy should ನೀವು ಅದ್ರ ಮೇಲ್ಗಡೆ ಓನರಿಗೆ ಹಾಕಿದೆ. ಇದರಲ್ಲಿ ನಿಮ್ ಕೇಸಲ್ಲಿ ಯಾರಿಗ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ? ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿನ ಓನರ್ ಟ್ರಾಕ್ಟರ್. Then therefore he has challenged. We are not liable. ಅಲ್ಲಿಗೆ 50-50 there is no dispute. Only thing is that there is a violation of policy condition. Yes, that's all. ನೋಡ್ರಿ ಅಷ್ಟರೊಳಗಡೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ಅದರ್ವೈಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಡಿಸ್ಮಿಸ್. Yes, next week at the request of the parties we will use this matter next week. Yes, Mr. Lingraj.
Yes, Lingraj for appellate method matter. Satish.
But we will dispose of Mr. Yes. Yes, that's all. Your contention. What is your contention? That is wrong. Yes. Yes, trailer tractor constitute a transport vehicle. Trailer and the accident is occurred by such tractor trailer, then vehicle caused the accident to the tractor alone, but it is tractor and trailer. Shri Satish, Learned Council appearing for the claimant has contended that the specific case of the claimant that driver of the tractor was rash and negligent in driving the same and dashed against that motorcycle bearing registration number KA42E85. Due to that impact, the rider has died in spot. The pillion rider was suffered an injury. It is nobody's case that the accident is caused by the trailer caused by the trailer. Even As per that IME report, there is no damage caused to the trailer. This fact has been admitted by RW1, who is the officer of the insurance company. The tribunal, contrary to that material available on records, contrary to that evidence of parties, has held that the accident is occurred by using of tractor and trailer both. Therefore, the finding of the tribunal that owner of the trailer is liable to pay 30% of the compensation is unsustainable. In respect of death of Prakash, the rider of motorcycle, which is related to MVC 1446 is concerned, he has contended that ಇದರಲ್ಲಿ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಇರಲಿ, ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ ಲಿಂಗರಾಜ್ ಅವ್ರ ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದು ಅಪೀಲಿಗೆ ಶ್ರೀ ಲಿಂಗರಾಜ್, learned counsel appearing for the insurance company, has contended that the accident is occurred due to the negligence of driver of the tractor trailer bearing registration.
ನಾನು ಮೋಟಾರ್ ಸೈಕ್ಲಿಸ್ಟ್ ಮೇಲೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಅವರ ಕ್ಲೇಮ್.
Yes, he contended that rider of the motorcycle, the deceased himself, is negligent in causing that accident. That driver of the tractor was not negligent in causing that accident. The tribunal is error in held that driver of the tractor has contributed 70% to the accident. He further contended that as per that sketch, it is, and Mahazor, it is very clear that it is an head-on collision. The deceased is also contributed to that accident. The tribunal is error in held that driver of the tractor alone is contributed to accident. Further contended that the claimant has, the insurance company has examined the officer of the company as RW1. He has categorically stated that driver of deceased, who is a driver of motorcycle, was negligent in causing that accident. The driver of the tractor was not negligent in causing that accident. He was taken care, he was following the all procedure of law and traffic rules. The tribunal, without considering that evidence of RW1 and without considering that IME report, Exhibit P3, Exhibit P4, rough sketch, as error in held that driver of the tractor was negligent in causing that accident. So and so, learned counsel appearing for the claimant has contended that when deceased Prakash was riding that motorcycle bearing registration number KA42E85 on left side of the road, the driver of the tractor was ridden the same in rash and negligent manner, dashed against the motorcycle. due to impact, Prakash has died. What is that name of the pillion rider?
Anwar Pasha. Anwar Pasha.
Anwar Pasha has suffered an injury. Anwar Pasha has been examined as PW2. He is an eyewitness to the accident. He has categorically stated that accident is occurred due to the negligence of driver of the tractor. He further contended that immediately after complaint has been lodged against that driver of the tractor, the FIR has been registered. After thorough investigation, police has filed a charge sheet. He would further contended that it is very clear from IME report, rough sketch, and IME report and rough sketch, it is very clear that driver of the tractor is negligent in causing the accident. He further contended that first trailer will not involve our contention.
Trailer ge damages illa anta.
Yes.
Trailer has
yes. That contention I have taken. Yes, that we have. That will. Yes. Avರಲ್ಲಿ ಇದನ್ನೊಂದು quantum ಬಗ್ಗೆ. He further contended that even though claimant has claimed that deceased was earning 7,500 per month, they have not produced any document to establish the same. Tribunal is error in considering that notional income of the deceased as 3,000. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is on higher side. In MEC 1447 of 2008, he has contended that the injuries suffered by the claimants are minor in nature. He has not examined the doctor. He has not examined the doctor. Considering that injuries suffered by the claimant, the overall compensation awarded by the tribunal just and reasonable. Lastly, he has contended that interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
8% ಕೊಟ್ಟಿದ್ದಾರೆ
8% ಇಲ್ಲ 6 ಇದೆ ಅಲ್ಲ
ಇಲ್ಲ
ಈ ಒಂದು ಕೇಸಲ್ಲಿ ಮಾತ್ರ 8% ಕೊಟ್ಟಿದ್ದಾರೆ
ಒಂದರಲ್ಲಿ ಡೆತ್ ಅಲ್ಲಿ 6% ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ನು ಇಂಜುರಿ ಅಲ್ಲಿ 8%.
The interest awarded by the tribunal 8% is on the in view of the judgment of this court. Interest awarded by the tribunal 8% is on higher side. Due to quantumly. In MEC 1446 of 2008 and 9, he contended that at the time of the accident, deceased was earning 7,500 per month. Tribunal has assessed notional income of the deceased as 3,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. And in view of judgment of apex court in case of Megma, the claimants are entitled 40,000 each. Hence, he sought for allowing that appeal by dismissing that appeal filed by the insurance company. In respect of MEC 1447 of 2009, he contended that due to that accident, claimant has suffered grievous injury. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal is on lower side. Hence, he sought for enhancement of compensation. Heard the learned counsel for the parties, Feroz, judgment and award. The case of the claimants that on 1/2/2009 at about 8:15 p.m., the deceased Prakash was riding that motorcycle bearing registration number KA 42E85 on Sathanur Kabal Road. See, Anwar Pasha was proceeding the said vehicle as a pillion rider. When they reached near Kabal Road at 8:15 p.m., the driver of the tractor bearing registration number KA05T 3702 and 1012, driven the same in rash and negligent manner, dashed against that motorcycle. Due to impact,
3708 my lord.
3702.
ಅಲ್ಲ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಷ್ಟೇ, ಬೇರೆ ಕಡೆ ಎಲ್ಲ 3708 ಇದೆ.
ಮತ್ತೆ 3708 and 1012. Due to that impact, the Prakash suffered an injury and succumbed to that injury. The pillion rider has suffered grievous injury. To prove the case, the wife of Prakash, Srimati Shaila, has been examined as PW1. Anwar Pasha has been examined as PW2. Claimant number 1 has reiterated her statement in claim petition, made in the claim petition. Anwar Pasha, who is pillion rider as well as an eyewitness to that accident, has categorically stated that the accident is occurred due to rash and negligent driving of driver of tractor. The claimant, the respondent, to disprove that case of the claimant, they have not examined the driver of the tractor. Who is the best witness to state about that incident of accident. Even as per the IME report and Mahazur and rough sketch, it is very clear that the accident is occurred due to the negligence of driver of the tractor. Tribunal, after considering that evidence of the parties and material available on record, has rightly held that driver of the tractor is negligent in causing that accident. Next paragraph. It is nobody's case that the accident is occurred due to use of the trailer. The specific case of the claimant is that the tractor has come and hit to that motorcycle. Due to impact, they fell down and suffered injury and succumbed to that injury. Even as per that IME report, there is no damage to that trailer. Only damage has been mentioned in related to that tractor. Even RW1 has admitted in his evidence that has admitted that there is no damage caused to that trailer. It is very clear from the evidence of the parties and material available on records. The accident is occurred due to the rash and negligent driving of driver of the tractor. The tribunal is error in held that the owner of the trailer is also liable to pay 30% of the compensation. To that, in respect of that part of the finding has to be set aside. Since it is unsustainable, the same is set aside. The insurance company is insurer of the tractor is liable to pay entire compensation of awarded by the tribunal. In respect of quantum, it is not in dispute. Prakash has died in road traffic accident occurred on 1/2/2009 due to the negligence of driver of the tractor. Even though the claimant has claimed that he was earning 7,500 per month, they have not produced any document to establish the same. Since accident is occurred 2009, as per the chart, the notional income has to be considered as 5,000. In view of judgment of apex court in case of Magma, in case of Pranay Shetty, since deceased was aged about 35 years, 40% of the income of the deceased has to be added for future prospects. He was a bachelor.
Wife and the children.
The tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. The multiplier applicable to that age group 35 is 16. Accordingly, loss of dependency has been reassessed as follows.
Plus 2,000 at the rate of 40%, 7,000 minus 2,333 at the rate of 1/3, 4,667, 4,667 into 12 into 16, 8,96,064.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the claimant number 1 is entitled 40,000 for spousal consortium, 2 and 3 40 each for parental consortium. In respect of MEC 1447 of 2009 is concerned, considering that evidence of doctor and considering that injury suffered by the claimant and considering that evidence of the parties, the tribunal is justified awarding the compensation of rupees 85,000. In view of judgment of this court, the interest awarded by the tribunal 8% has to be reduced to 6%. Accordingly, the appeals are disposed of.
Amount in deposit.
Amount in deposit is transferred to the tribunal.
Cross objection.
Cross objections allowed by court. Outer delay.
Yes, cross objection. The elderly delay. Yes, to elderly same delay. In view of order dated 12/11/20, the claimants are not entitled for the interest for a period of 549 days.
67 early, pending.
All pending applications are disposed of.
67.2 ಮತ್ತು 67.3 ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ ಸರ್ 2A 2D and 3.
ಯಾರ್ರಿ ಅವರು ನಿಮ್ದ್ರಲ್ಲ
Dispensation
ಕೊಡ್ರಿ ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಅಲ್ಲ ಅವರು LRs of the owner ಅವ್ರೇನ್ ಬೇಕಾಗಿಲ್ಲ ಇನ್ಶೂರ್ಡ್
ಅಲ್ಲ ಈ ಪ್ರೋಸೆಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಮೆಮೋ ಕೊಡಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಫೈಲ್ಡ್ ಅನ್ ಮೆಮೋ ಹೆನ್ಸ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಅಂತ ಹಾಕಿ
ಮಚ್ ಒಬ್ಲೈಕ್
Whatever matter, serial number 13, Kavita HC for
Yes, Mr. ಕ್ಲೈಮೇಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ ಹೋಗಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಕರ್ಕೊಂಡು ಬಂದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡೋ ಸ್ಟೇಜ್ ಬಂದ್ಬಿಡ್ತಲ್ರಿ ವಾಟ್ ಇಸ್ ದಿಸ್ ಮಿಸ್ಟರ್ ನೋ ಬಟ್ ಬೆಳಿಗ್ಗೆ ಎಲ್ಲಿದ್ರಿ ನೀವು ಬಂದಿದ್ರ ಬೆಳಿಗ್ಗೆ ಯು ಆರ್ ದೇರ್ ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ಪಾಸ್ ಆದಾಗ ಬರ್ಬೇಕಾ ಬೇಡ ಕ್ಲೈಮೇಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ ನಾನ್ ಅನ್ಕೊಂಡಿದ್ ಕ್ಲೈಮೇಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ ಕಾಯ್ತಾ ಇರ್ತಾರೆ ವೆನ್ ದ ಕೋರ್ಟ್ ಈಸ್ ಫ್ರೀ ಸಿಕ್ಕಿದ್ರೆ ಸಾಕು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಅವ್ರನ್ನ ಫೋನ್ ಮಾಡಿಸಿ ಕರ್ಸ್ತೆ ನಾನು ಲಿಂಗರಾಜ್ ಅವ್ರ ಹತ್ರ ಹೇಳಿ ಈ ವಾಸ್ ನಾಟ್ ದೇರ್ ಅಟ್ ಆಲ್ ನಾವು ಬೆಳಿಗ್ಗೆ ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡಿ ಫೈನಲ್ ಬಂದಿದ್ದು ಲಿಂಗರಾಜ್ ಹ್ಯಾಸ್ ಕಾಲ್ಡ್ ಸಿ ಇನ್ ಕ್ಲೈಮೇಟ್ಸ್ ಕೌನ್ಸಿಲಿಗೆ ಯು ನೋ ದಟ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟೀಸ್ ಯು ಆರ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ದಟ್ ಪರ್ಸನ್ಸ್ ಹೂ ಹ್ಯಾಸ್ ಲಾಸ್ಟ್ ದೇರ್ ಲೈಫ್ ಮಿಸ್ಟರ್ ಆಯ್ತು ನಾವು ಜನರಲ್ ಆಗಿ ನಿಮ್ಗೆ ಒಬ್ರಿಗಲ್ಲ ಓವರ್ ಆಲ್ ಮೈ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ದಟ್ ನಾನು ಇನ್ಸೂರೆನ್ಸ್ ಲಾಯರಿಗೆ ಹೇಳ್ಬೇಕು ಅವ್ರನ್ನ ಕರ್ಕ ಬರ್ರಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋ ನಾಳೆ ಮ್ಯಾಟ್ರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾ ಆಕ್ಚುಲ್ ಆಗಿ ನೀವು ಕಾಯ್ತಾ ಇರ್ಬೇಕು ಸಿಕ್ಕಿದ್ರೆ ಸಾಕಪ್ಪ ಕೋರ್ಟ್ ಟೈಮ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ನಮ್ಮ ಬರೋದೇ ಅಲ್ಲ ನಾನ್ ನಾಟ್ ದಿಸ್ ಕೇಸ್ ಜನರಲ್ ಆಗಿ ನಾನು ಹೇಳಿದ್ದು ಯಾಕೆ ಅಂತ ಅಂದ್ರೆ ನೋಡಿ 2012 ಟೆಲಿಂಗ್ ಅಬೌಟ್ ದ ಕ್ಲೈಮೇಟ್ಸ್ ಅವರು ಫ್ಯಾಮಿಲಿ ಕಳ್ಕೊಂಡಿರ್ತಾರೆ ಅವ್ರು ದೇ ಆರ್ ಇನ್ ದ ಟ್ರಬಲ್ ಯಾವಾಗ್ಲೋ ಕೇಸ್ ತೀರ್ಮಾನ ಆದ್ರೂ ಸಾಕಪ್ಪ ಅನ್ನೋಬೇಕು ಬರೋದೇ ಇಲ್ಲ ನೀವು ನಾವೇ ಕರ್ಸ್ಬೇಕು ಎಸ್ ಹೇಳಿ ವಾಟ್ ಇಸ್ ದಟ್ ಕೇಸ್ ಎಸ್ 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 ಕರೆಕ್ಟ್ ಇದೆ 62-22 ಇನ್ಕಮ್ 30,000 ಹೇಳಿದಾರಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 2017 ಗೆ ಎಷ್ಟಿದೆಯಪ್ಪ 11,000 ದಟ್ ವಿ ಆರ್ ಕನ್ಸಿಡರ್ ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ 46 ಡೇಸ್ ಏನ್ ಇಂಜುರೀಸ್ ಅಪ್ಪ ಎಷ್ಟು ಫ್ರಾಕ್ಚರ್ ಇದೆ Yes. Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ. Medical expenses. Loss of later period. Amenities 20 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಒಂದು ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. That's all. Interest ಎಷ್ಟಿದೆ? What is that? Yes. So and so learned counsel appearing for the claimant has contended that at the time of the accident, he was aged about 35 years, 38 years, and he was at the age at the time of the accident, he was earning 30,000 per month as a painter. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. Further contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 46 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Bini Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 8,000 per month. He further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 22/5/2017 due to rash and negligent driving of driver of Tata Sumo bearing registration number KL14 N3826. Due to that accident, claimant has suffered the following injury. The tribunal, after considering the evidence of doctor injury suffered by the claimant, rightly assessed whole body disabilities 22%. Even though claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. In the absence of evidence regarding his income, the notional income has to be assessed as per the guidelines issued by Legal Service Authority. For the accident occurring 2017, notional income has to be considered as 11,000. At the time of the accident, he was aged about 38 years. The multiplier applicable to the age group is 15. Accordingly, loss of future earning reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 46 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 20,000 to 40,000. Loss of income during the later period for 3 months. Enhanced compensation amount carries 6% interest. Notice to so and so is dispensed.
41, Maruti for appellant, Mrs. Sitaram Rao.
Hello, for the
Yes,
respondent.
Yes.
Hello, there's another connected matter, my lords. MFA 6371 of 2012, my lords. The same may be connected to yours.
filed by insurance company or a party? Claimant.
By the claimant, my lords.
Yes, call this matter along with that. So and so. Yes, let that. Yes.
6371 of 2012.
Yes, yes.
Court officer. Court officer. ಯಾವುದು ಸರ್ 59
69 69
69 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಿದೆ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಿದೆನಾ?
ಹೌದು ಸರ್.